8 accused persons, but for now we have Mr. Thabo Bester, who is appearing via AVR. He is appearing from the Hosi Mampuru Correctional Facility, and Mr. Ishmael previously Mr. Kapidi from Ishmael Attorneys was on record, but today Mr. Ishmael is appearing, and my understanding is that he needs to address the court regarding his involvement in the matter going forward. As it is.
First and foremost, where is Mr. Kapidi?
Your Worship, he is an associate in my office, so both from our station and attorneys, I'm here on behalf of the office.
Yes, what is the position, Mr. Ishmael?
Your Worship, the court will remember on the 14th of April, Mr. Kapiri from my office appeared, he came on record for Mr. Dexter. He's number 5. On that day, I was not in court. I had already received instructions at that stage on behalf of accused number 2. I went to consult with accused number 2 that weekend, the Saturday, I believe it was the 15th. And then I foresaw there might be some issues. So I decided I'm not going to go and consult with Mr. Dexter. Mr. Kapiri also didn't consult with him because there was an opportunity in court. We were supposed to go to Pretoria at a later stage. That Sunday when I spoke to Mr. Besser on the phone, I told him, look, I foresee issues that I'm representing accused number 2. I'm not going to come and consult anymore. He was aware that I already withdrew between him and I. And then today I'm just coming to court to officially withdraw. Since the 16th of April, he was already aware. He was already approached by another legal representative. He has a new legal team already. They will now come on record after me if the court will allow me to withdraw.
Let me establish with you. Today, an audiovisual recording has been arranged. Are you satisfied with the setup? Are you satisfied with the...
Your Worship, well, as I said, I have already withdrawn between myself and Mr. Besser. I haven't been his legal representative for a while now. I'm only coming today to formally withdraw in court. That can be dealt with his new legal representatives. And they have, I do believe they do have instructions and they will address the court on that.
Mr. Besser,
Yes, sir.
are you following the proceedings?
I can hear a bit faintly.
Didn't you hear the attorney, Mr. Ishmael, addressing the court?
I heard him.
Right. He informs the court that he is withdrawing from records as attorney of record.
Okay. That is fine.
Thank you. Application by Mr. Ishmael to withdraw as an attorney of record is hereby granted.
Yes, please, the court, Your Worship. Your Worship, that's my rule, may I be excused.
Right. Mr. Bester, you are excused. Mr. Bester, you've got the rights to legal representations. You may appoint an attorney at your own cost. If you can't afford to pay one, then you may approach Legal Aid South Africa to represent you free of charge, or you may elect to proceed on your own. in this matter. Do you understand?
Yes, I do.
What do you elect to do?
I have a legal team that is Mr. Pida and will take over my.
May you repeat yourself?
I have Advocate Pida and Bo that will be taking over my.
I do see before me, I do see Advocate Pila. Let me,
Yes.
Yes, let me engage him.
God bless the Worship. Worship, confirm my appearance on behalf of accused. I'm on the instruction of Tindo attorneys, and the instructing attorney, Mr. Tindo, is here with me, Worship. Please, the court.
Thank you. Mr. Matuko.
Yes, as you please, the court, Your Worship. Your Worship, let me first indicate that the main matter will be dealt with in 3 phases. We are now dealing with Mr. Thabo Bester, and we will also be dealing with the matter of Ms. Nandipa Magudumana, also visually. Unfortunately, Court 19 in Bloemfontein is not connected to the Kroonstad correctional facilities, and therefore we will connect via MS Teams, and that will be in Court 28. From there, with the rest of the accused, we will then go back to Court 17, where we will be postponing Mr. Sekeleni, and thereafter we will then be proceeding with the bail application. Joseph, in terms of the main case, there has been some engagement with all the representatives, including Advocate Pela, who is now on record, and there is an agreement that the main case be postponed to the 20th of June 2023 for further police investigations. I am also made to believe that Advocate Pela requested to address the court on a separate aspect just before we do the postponement. I will then pause to ask that Advocate Pela perhaps then addresses the court on whatever aspects he intends addressing the court, as he pleases.
God bless you. Worship, just the brief background regarding the visual hearing. The prosecutor, Dr. Masoko, called my instructing attorney last week Friday in the afternoon, requesting this matter to be visual, of which as the defense we have proposed to the visual hearing. One, it's inconveniencing for us. We need to take the instruction from the client, and as the setup it is now, Your Worship, we can't take instructions from the client, because as we are taking a particular legal issue with the client, everyone else will be listening. And throughout the proceedings, from time to time, there will be a need for the legal team to confirm something with the client. So we just want to bring it to the attention of the court that we never agreed with the visual hearing. And the prosecutor or any other person never came back to the instructing attorney to say whether the visual has been granted or not. We are also taken by surprise when we get to court today. We're expecting to meet with our client before we commence, because there are a few issues that we wanted to iron them out with him. We're surprised to see that there is a visual hearing today, of which he never agreed to. The issue that we want to converse to court, Your Worship, with the court's leave, we request to have our client transported here, being tomorrow or a day after, there is an issue that we want to bring to the attention of the court. However, it's important for our client to be here so that should there be any questions raised and the need to consult, we have that flexibility and opportunity to consult with the client. This morning we tried to talk to the client. It was very difficult through this visual setup. So, Your Worship, our request is that we don't have a problem with the postponement for further investigations. It is correct that the state did canvass the issue with us, that we don't have a problem. But our request is that there's an issue that we want to bring to the attention of the court with our client present physically in court. So with the court's leave, Your Worship, we request the matter to be rolled over to any other day, preferably tomorrow, so that we can deal with the matter that we want to bring to the attention of the court. Court, please.
Before you take a seat, I have heard the public prosecutor testimony that as for the meaning, he has discussed the matter with the defense and agreement was reached that the matter be postponed until the 20th day of June for further investigation.
Court, please, it is correct, Your Worship. That's the one that I was saying. For further investigations, for the matter to be remanded to 20 June, we don't have a problem for all the accused. However, we request our accused to be made available tomorrow. There is an issue that we would like to bring to the attention of the court with him being present in court, so that should we need to take further instructions from time to time, he's easily accessible. The visual is not working for us. I don't know about other legal representatives, but for us it's not working. Court, please.
Thank you. Yes,
As it is indeed so that last week Friday, the court shall recall firstly that I placed it on record when we postponed the matter that DCS has requested that we consider the option of a visual postponement, which I placed on record. Subsequent to the court adjourning, I approached the attorney who was on record. That would be Mr. Kapidi. And that's where I got the confirmation that he will be withdrawing as attorney on record. He then alerted me to the fact that Mr. Ndou appears to have now instructions to represent Mr. Bester. And I indeed contacted Mr. Ndou after obtaining his contact from the said Mr. Kapidi as a courtesy call. Remember, he is not yet on record. He only comes on record today. But as a courtesy call, I made him aware that there is this issue of visual. Indeed, he told me that they are opposed to the visual postponement. I then indicated that, by the way, he is not yet on record. And I was just giving him a courtesy call. That's the first issue. Yes, so it is not clear from Advocate Pela what application they intends bringing. I understand him to be saying they request that Mr. Bester appear in person tomorrow for an application that they intend bringing, and that it is difficult to consult with him by AVR. The court needs to separate the issues. Nothing stops them to consult with Mr. Bester. On their own, they need to go and consult with him wherever he is. It is not for the state to transport Mr. Bester so that they are able to consult with him. They can consult with him at any time with the necessary arrangement with the correctional services, and that's it. It would appear that they expect the state now to facilitate that consultation that he intends having and to then transport Mr. Bester for his appearance. Your Worship, Section 159 capital A of the Criminal Procedure Act makes provision for the AVR unless the court orders that it is in the interest of justice that the accused appears, which I do not know, which I do not hear so far in terms of what is that they intend bringing before the application, bringing before this court. Safe to say they request that the matter be rolled over until tomorrow so that Mr. Bester appears. Only then will they bring the application. But the court is unable to make an informed decision unless we are provided with details of this application and the like. That is my view, Your Worship. I don't see why Mr. Bester needs to appear for tomorrow. We are agreeable that the matter still requires some further investigation, and the state is bringing an application for the postponement of the matter for further investigation. Whatever application they intend bringing, let us be enlightened about it. As it pleases the court, Your Worship.
Court pleases, Your Worship. Your Worship, I think the state missed the boat altogether. They misunderstood us. We don't request our client to be transported to court for consultation. No. It is the right of the client to appear in court in terms of the Constitution of the Republic of South Africa under the fair trial. Fair trial, amongst others, includes the accused being at court, being able to easily consult with the legal representation and so on. We have been to Kgosimampuru more often than not. We have consulted with the client. We don't need state to bring our client here for consultation. That's not what we are saying. The issue that will be bringing to the court as a preliminary issue requires our client to be here so that should the court, honorable court, ask us any question, we're able to quickly confirm with him and consult with him. And it will make the work of this honorable court very easy. Your Worship, I don't know if you will allow me to give a glimpse of the preliminary issue that we want to raise with the court.
Yes, because
Court pleases, Your Worship. Let me bring the glimpse. This honorable court will remember when Dr. Magudumana appeared for the second time. This honorable court instructed Dr. Magudumana to remove the mask and the head so that the court can satisfy itself that the accused before the court, it is indeed the correct person. Your Worship, the preliminary issue that we are going to raise is that by the same token, we request this honorable court also to confirm and satisfy itself that the accused before court is the correct accused. It is against this background that we bring this preliminary issue. The warrant of arrest was issued, J50, for the arrest of Thabo Bester. A gentleman was brought to court and the warrant was cancelled by this honorable court to say this is Thabo Bester's warrant of arrest. We want the court to satisfy itself, Your Worship. Apart from J50, that warrant of arrest, nothing was finished to the court in terms of documentation, confirming that the accused before you is Thabo Bester. Your Worship, there is a purported death certificate of Thabo Bester. That will also request it to be confirmed so that the court can satisfy itself. This purported death certificate is dated 3 May 2022, and it has got a stamp that is purported to be the Home Affairs stamp. So if we say there was a Thabo Bester in cell 35 at G4S, and after the fire and someone died, there is a death certificate, purported death certificate. I'm saying purported until such time that it has been confirmed, if this is true, by Home Affairs. And at a later stage, there is a warrant J50 issued for the arrest of Thabo Bester. And someone is brought before you, Your Worship. Remember now, somebody escaped. There is a death certificate of that particular person, the purported death certificate. There is a J50 issued by the Honorable Court, and all of a sudden there is a gentleman that is brought. Our request is that, can the court satisfy itself that this J50 that I've cancelled, there is a documentation supporting that it is indeed this person that is before me, Thabo Bester. That's the issue that we'll like to take with the court as a preliminary issue before we come to the postponement. Can the state at least satisfy the court with any form of documentation that the person before you is Thabo Bester? That's our request, Your Worship.
Mr. Taylor, this court has got no reason to believe that the wrong person was brought to be found out. The basis for that is that at first appearance, Mr. Thabo Bester was legally represented, and issue of identification was never raised at first appearance. So based on that, I've got no reason to believe that the wrong person was brought. Because if a wrong person associated with the name of Thabo Bester was brought before me, that issue should have been canvassed there and then. But it did not. So why should the court have reasonable belief that the wrong person was brought?
Court pleases, Your Worship. Your Worship, this Honorable Court will recall the issue of confirming the identity of Dr. Magudumana was never done on the first instance. It was done when she was appearing for the second time, where the court wanted to satisfy itself that the accused before the court is indeed Dr. Magudumana. But it was never done on the first time. She was wearing her hat and her mask, with due respect, Your Worship. It was only done on the second time. Same applies to our client. First appearance, it was never entertained. We are saying to this Honorable Court with due respect, can the court satisfy itself, like it satisfied itself with the issue of Dr. Magudumana? And Your Worship, we can't even take the responsibility why the previous legal representative did not take up the matter. Us, as the incoming legal representatives, we have been instructed to address the court on this issue. But if the court is satisfied without having received any form of documentation that confirms that the person before the court is indeed Thabo Bester, then we don't have a problem. We just wanted the court to be satisfied. Because the only thing that is in possession of the court, like previous appearance, Your Worship, it was only the J50 with the name of Thabo Bester, nothing else.
But Mr. Taylor, your comparison refers to the lady who appeared before me. But the lack of affidavit, it's misplaced. Because the person hid herself. It was as good as that person was found. That was the reason for the confirmation of her identification. Mr. Bester appeared without having hid himself. So you can't compare the two.
Court pleases, Your Worship. Your Worship, we are in the court's hands, but our issue was that can the court satisfy itself that the person before the court is indeed Mr. Thabo Bester? But if the court is satisfied, we are indebted to the court.
Yes, what is your response? The public prosecutor felt that addressed the court to see when you made an objection through the instructing attorney, you were not authorized. And you could not have agreed as to whether visual, audio visual recording be proceeded or not. What is your reaction?
Court places, that is correct, Your Worship. The courtesy call that the state gave the instructing attorney warranted the response. It was not just a courtesy call to say, I'm calling you to inform you that there'll be a visual. The state went to the extent of canvassing the response from the legal team. As much as we are not on record, I agree with the court 100%. However, we had to give the response whether we'll be comfortable with the AVR or not. And the instructing attorney's response was that, no, will not be comfortable. Now that we are on record, Your Worship, that's the first issue that I dealt with. To say the AVR is not working for us, I don't know about other legal practitioners. So moving forward, we'll request our client to be physically present in court. Court, please, Your Worship.
Yes, if I may be allowed. Advocate Pila is unfortunately dealing with evidence or a piece of evidence which is the subject of the charges against the very same Thabo Bester. The death certificate, which he says is purported to be a death certificate, it is precisely the reason why we are here today dealing with this kind of cases, because someone is alleged to have died in the fire, which the state is saying it was not. And therefore, it is the subject of the charges that are there against it. It has got nothing to do with the court satisfying itself with the identity of Thabo Bester. There's a person there in the accused dock who happens to be Thabo Bester, who is the accused. And I see no reason why, for that purpose, the state needs to transport Mr. Thabo Bester to come and appear here tomorrow. In fact, Advocate Pela has already dealt with that issue, what the issue is about. And I concur and agree with the court that he cannot make comparison with the situation of Ms. Nandipa. It's two different issues altogether. And the issues that they want to raise are issues that should, in my view, be reserved for trial when we deal with the trial, as and when we deal with the trial. As it please the court,
Thank you. Ruling. As for the application moved by Advocate Taylor, but less persuaded for the lack of merits, application is dismissed.
Court, please.
As it please the court, Worship, on that basis, I request that the matter against Mr. Thabo Bester be postponed to the 20th of June for further police investigation. That he remains in custody, as it pleases.
Court, please, Your Worship, the 20th is suitable for the defense.
Thank you. Mr. Bester, your case,
Yes, sir.
your case is remanded until the 20th day of June 2023. Court number 28 for further investigations.
Will it be virtual?
You will remain in custody until then.
Will I come to court or will... Oh, no.
As to whether it will be virtual or you will come to court, that will be canvassed in due course between the state and the defense.
Thank you.
As please, may we then adjourn for now and move to court 28. I will give an indication in terms of the readiness for us to proceed. As please.
Court adjourns.
All rise.
Right, the matter postponed to the 20th of June involving
Martini Mutunyosip is appearing for Ms. Magudumana, who is on record in terms of the charge sheet is accused number 4. The state reports that as per the proceedings of the previous accused, that the matter against this accused to be also postponed until the 20th of June 2023 for further police investigations that she remains in custody. The date was arranged with Mr. Machidi.
As please court, Your Worship, I confirm that I appear on behalf of accused person. Furthermore, confirm that the date of the 20th of June 2023 for further investigations has indeed been arranged with me. Your Worship, you would recall that in terms of the record, that the accused has reserved his right to proceed with his bail application. That is still the position. Notwithstanding the arranged date, we had a discussion with the state that in the event of any possibility arising, we may approach the state accordingly. But for now, Your Worship, the date of the 20th of June 2023 for further investigation is suitable, as the court pleases.
Thank you. Mrs. Magudumana, are you following? Do you hear the proceedings? Yeah, in short, the first person who spoke was the public prosecutor, who made an application that the case be postponed to the date of the 20th day of June 2023 for further investigations. Then the second person who spoke was Mr. Mutoung, your legal representative, who agreed as to the date of the postponement, which is the 20th day of June 2023, for further investigations. Do you understand? Thank you. Your case is accordingly remanded until the 20th day of June 2023 in court number 28 for further investigations. You will remain in custody until then. You have reserved your right to bail application, and that right is kept in abeyance, as was previously requested. Thank you.
As the court pleases, Your Worship.
The court pleases, we may then move to appearance of other accused.
Court adjourns. Can transport you all guys.
2, 3, 6, 7, and 8. We already dealt with the case relating to others. Your Worship, the state will similarly ask that the matter against the accused before court be postponed until the 20th of June 2023. The date has been arranged and agreed upon with all the legal representatives present here today. Accused number 2, Mr. Sekeleni, is out on bail. The state requests that the bail be extended on the same conditions. The rest of the accused will then remain so that we proceed with the bail application. As a please,
Mr. Muru.
As the court pleases, Your Worship, I confirm my appearance on behalf of accused number 1 and accused number 7. And I do confirm that the date of the 20th of June is suitable with us, Your Worship. As the court pleases.
Mr. Diva.
May it please the Honorable Court, I confirm my appearance on behalf of accused number 2, and I also confirm that the date is suitable, the 20th of June 2023. As the court pleases.
Thank you, Mr. McNeil.
Thank you, Worship. Worship, I appear on behalf of accused number 3 in this matter. I confirm that the date has been duly arranged with me. Thank you.
Please the court, Your Worship, I confirm that I appear on behalf of accused number 6, and I certainly confirm further that we have agreed with the state that the date of the 6th, the said date has been 20th of June has been agreed upon. Court pleases, Worship.
As it please the court, Your Worship, I confirm my appearance on behalf of accused number 8, Your Worship, and Mr. Gary Botha from Gary Botha attorney schemally. I confirm the date of 20 June 2023, Your Worship, as it please the court.
Thank you. Right. As for now, accused number 2, Mr. Sekeleni, your case is remanded until the 20th day of June 2023 for further investigations. You are on bail. You are warned to come back to this court at 8:30 in the morning and to remain in attendance. Failure to appear, warrant of arrest will be issued. Your bail will be provisionally cancelled. Bail money be provisionally forfeited to the state. The previous conditions as to your release on bail still remains. You were ordered to report yourself once a week at any time between 8 o'clock and 4 o'clock in the afternoon at Port Edward Police Station. You may not leave the magisterial district of Port Edward without having reported yourself to Colonel Flyman. You may not directly or indirectly contact the state witnesses. Do you understand?
I understand, Your Worship.
Thank you. You may stand down.
That completes my appearance before this honorable court, Your Worship. May I please then be excused.
Excuse that. Thank you, sir. Yeah, for record purposes, appearances are same as before. The Colonel Flyman was still under oath. Colonel Flyman, you are still bound by the oath that you previously took. I just want to confirm with you. Do you confirm that the evidence that you will further elicit before this court will be the truth, nothing but the truth? If so, raise up your right hand and say, "Help me, God." Thank you. When this matter was adjourned, the state had already closed Evidence in Chief. Mr. Morori, I'm not sure whether you are ready to proceed.
Mr. Court, pleases Your Worship, I am indeed in a position to proceed. Your Worship, perhaps once more for housekeeping purposes, I seem to believe that the cameras may be rolling. See, one is pointed at me, and another one is pointed at the accused doc. If perhaps I could just ascertain as to the position, Your Worship, in as far as that is concerned.
Yes, Mr. Morori, thank you for bringing that to court's attention. Since the matter was adjourned, there were new developments. I must state that after the limitations were made to the media house, the representations were made to this court as to permit the media house to proceed to broadcast the proceedings live. And attention was brought to this court that this court, it might have extended its power beyond its limit, in the sense that this court did not afford the affected party or parties, in this regard the media house, a space to react or to air out their views, as one would know that at all times the principle of natural justice ought to be observed. In other words, this court was myopic in exercising properly or observing the principle of natural justice, specifically the audi alteram partem on the part of the media. And what may seem to have been the order of the court might have arrived invalidly so, in the sense that the court might have acted ultra vires, and I am specifically taking piece by piece from the representation that were made to this court. And if the court could have acted ultra vires, in other words, if the court had made invalid order, that order would not be binding. I'm not sure whether you are following.
Your Worship, I accept what the court is telling me. However, Your Worship, I beg to respectfully differ with the court. This honorable court made an order. And that order, unless rescinded or set aside, still stands. It is a binding order. If it is that the court may have granted, it is so that the court may or may not have granted it erroneously. But that is not for this court to decide. If this court now says it is recalling its own order, it cannot do that, with the greatest of respect, Your Worship. The court is factus officio in this, in as far as this aspect is concerned. It made a pronouncement, and that pronouncement was to the effect that I give the following order, and that order carried, Your Worship. And those would be my submissions, Your Worship. Unless the court is saying it is reviewing and setting aside its own order on account of its invalidity, and which we know the court cannot do.
Yes, let's check. The affected party was not given an opportunity to respond, correct? Is that correct, Mr. Morori? The
Yes,
affected
yes, Your
party
Worship.
being the media.
Yes, Your Worship.
Right. And will you agree with this court that this court might have been myopic so far as the principle of natural justice is concerned?
Yes, Your Worship.
Specifically observing the audi alteram partem rule.
That is so, Your Worship.
And court having arrived into the conclusion and made that order on the basis that the court did not observe the principle of natural justice, that order might have been invalidly arrived at.
That is so, Your Worship.
And then if the order is invalid, will you then agree with me when I say the order that is invalid from the court cannot be binding on the basis of it being invalid inception?
Your Worship, I respectfully wish to and beg to differ with this honorable court. And the words used by the court are correct. It says it might have been arrived at invalidly. So the avenue used may be incorrect. But the fact that an incorrect avenue used arrived at a certain order does not invalidate the order. An order of a court stands until it is set aside by a superior court. As things stand, this court gave an order. And if it goes on review, this court can say, I accept that I may or may not have erred. And that is a different discussion for another day. But as things stand, the court granted an order. All court orders are binding until set aside, Your Worship. The court cannot say, I think I made a mistake, and I therefore recall my own order. That would be incorrect, Your Worship. That would be a serious transgression on the rules that we have of this court.
Yes, in the same breath, would I also be correct to say, having not observed the principle of natural justice properly, and then having not afforded the media house an opportunity to respond or to react, I might have acted ultra vires so far as the order is concerned?
That is indeed so. Those are grounds for a review, Your Worship. And that is not an entitlement for the court to recall its own order. Beautiful grounds for a review, and should that come to that, then that can be canvassed at the right platform. As things stand, this is not a review. The court has made an order. We accept. To err is human. And if the court says, I may have erred, and I think I erred, that is correct. There's nothing wrong with that. But it is not for this court to recall its own order and then say, I think I erred, therefore I'm recalling my own order. It would make a serious problem. It would cause a serious problem. Because the rules are there for a reason. To say once you have pronounced on something, you cannot go back again and pronounce on the same aspect.
I understand.
And the pronouncement has been made here.
I understand that, Mr. Morori. Let me ask you the last question. Can invalid orders be binding?
Indeed so, Your Worship. Until set aside, invalid orders are binding. Those are binding, Your Worship. Whether they were granted validly or invalidly, once there's a court order, it must be complied with to the T until it is set aside. And that is where we are, Your Worship.
Thank you.
Ask the court, please.
Thank you. Mr. Makamedi?
Thank you, Your Worship. Your Worship, I fully agree with what my learned colleague is saying before this court. Your Worship, the order that was given by the court, whether invalid or erroneously given, it's still binding. There was an order that is final. It's not interim. There was no rule needed to say that we'll come back on this issue at a later stage to come and discuss that. So it is validly binding, and the only option available for this court is to have that order reviewed.
May it please the court, I concur with my learned colleagues, and I do not want to add further on what has been said so eloquently. And I rest.
Yes, please, the court, Your Worship. I will abide by the decision of the Honorable Court, Your Worship. Yes, please, the court.
Right, state, let me listen to the state. The views, if any.
I understand the court to be saying that the media house was not afforded an opportunity to air their views. But the fact of the matter is, initially they brought an application so that their views was not canvassed. In my view, I want to submit that they were actually canvassed, because they are the ones who initiated that. They brought an application, and based on their application, the legal team, we all converged and had a kind of a meeting, and based on our views, then there was this order. So all the parties' submissions were taken into consideration when the order is made. I want to submit that is the position. It cannot be correct that they were not given an opportunity, because they brought an application of which was granted, and having granted that application, the parties then subsequently made their submissions, and based on those submissions, that order was then made, specifically paragraph 1.3 of the addendum. So all parties' views were taken into consideration. And other than that, I will also abide by the decision of this court, insofar as that is concerned. As it pleases.
Thank you. My ruling on this matter, and I will align myself with the decision of Master of High Court, Northern Gauteng High Court, Pretoria versus Motala, Nomino Ofokio and others, 2011, whereby the principle that was tabulated there is being used by this court today, that invalid orders are necessarily not binding until they are being taken to appeal. Having said that, I do order that the amendment as per the guidelines that was initially issued be put into effect, in that media house is allowed to broadcast live these proceedings. And I must further indicate that it will also be in the interest of justice for court to arrive into this decision. The issue of broadcast by media live, it is a collateral issue, by the way. The main issue here, it is the bail application of the accused before me. And when this application was made for the purposes of limitation, there is no any form of prejudice that was indicated to me that should the proceedings be broadcast live, then there might be any prejudice to any of the party to the proceedings. And to keep this matter in abeyance, or to adjourn this matter for the purpose to consider otherwise, it will further delay these bail proceedings. It is in the interest of justice that we proceed with the bail application in this form. Thank you.
As the court pleases. Your Worship, may I turn my back on the court to take an instruction?
Yes.
Just before you take instructions, can there be some limitations placed on that?
Thank you, Mr.
In the form of my request will be, as much as the audio of witnesses may be live, I don't mind, but then the face and the identity of the witness that is now giving evidence strictly be prohibited. That will be my submission, Your Worship.
Okay. Perhaps to bring into the records the amendment as brought forth by this court. This will read thus. Everybody will remember that this court read out clause 1.3 previously as per the guidelines. And as per this amendment, you will indicate the following: this to your clients with regard to the contents of clause 1.3 of the addendum, as informed by the guidelines that were set. As is currently happening, SABC fits into other media houses. For this purpose, 1 or 2 static cameras will be allowed for the live recording of the proceedings. That simply means to indicate real time. All the bail proceedings will be thus as recorded. In the event that a concern be raised with regard to the revelation of the identity by the state of any witness, it shall be abided by. Should there be disagreement or objections, then the presiding officer will make a ruling. No interview of any of the accused persons should be conducted in court. No roving cameras and disruptive movements by media personnel in the courtroom. No taking of photographs will be allowed during the court proceedings. Other unforeseen issues around the media on the part of the legal team and or the state that may come up during any stage of the proceedings will be raised and decided there and there by the presiding officer. All the other issues in the addendum relating to the decorum of the court still stands and should be adhered to. I want to believe that is clear. And Mr. Matoko, that also covers your concerns. Thank you,
Mr. Court, please, Your Worship. May I turn my back on this court to take an instruction?
Yes, you may.
Mr. Court, Mr. Court pleases, Your Worship. Your Worship, I'm indebted to this honorable court for the indulgence. I am in a position to proceed, Your Worship.
Thank you. Are you ready, Lieutenant Colonel Flyman?
Yes.
Thank you. Mr. Murori, with the permission of the court, you may kickstart with your cross-examination.
Mr. Court, please. Colonel, good afternoon. Colonel, before we start, it would be inappropriate of me if I did not commend you on your 28 years of selfless service to this country. And I think I speak for most of us when I say we are indebted to you.
And Kiahola had to work on a city villa, they were sitting more than about Cabana, right? Libuela, sitting to how 8 matter. I thank you.
Colonel, being an officer of 28 years in the South African Police Service, am I correct to accept that you understand that the purposes of this bail hearing is not to determine the guilt or otherwise of any of the accused persons, applicants before this court?
Colonel Jologa, when I was people about 28 years, or less bonusing. Ketanka hore wa utlwisisa hore sepheo sa bail ena kapa kopo ena ya bail ha se o bontsha tsa hore na mang o molato mang ha molato le in dintho tse jwalo ke bontsha fela ke o tseba sepheo sa bail ke
Ho jwalo, Your Worship.
I understand that.
And in your own words, what would you say is the purpose of bail proceedings?
A go re bolele ka mantswe a hao. O tla re keng sepheo sa hore ho be le ntho e o thweng ke bail kapa ho be le tshebetso e tje kopo e tjena ya bail?
Ke ho etsa surety ya hore moqosuwa o attenda court, Your Worship.
Well, the bail application would be to make sure that an accused person does attend court.
And you testified, Colonel, in exam-in-chief that your investigations are not complete. Is that correct?
When I know bopaki ba hao he ha no bolela mona o itse diphuputso tsa hao ha di so felle ha o so qeta.
Ho jwalo, Your Worship.
That's correct.
And you further indicated that it would take you another 2 months or so to finalize the investigations.
And when I know akanyetsa fela o lekanyetsa o itse ntwena e ka nka di kgwedi tse pedi ho qetella.
Ke itse kgwedi kapa kgwedi tse pedi, Your Worship.
Yes, I said it could take me from a month to 2 months to complete the investigations.
Furthermore, you also
Yeah, Mr. Mururi, don't fly. I must also take notes.
must apologize.
Thank you.
I must apologize. I'll
Thank you.
slow it down. As the court pleases.
Yes, thank you.
You also indicated, Colonel, that you envisage that there will be more arrests in this matter.
And when I itse o na le ponelo pele hore ho santsa no na le batho ba bang hape ba ntse ba tshwarwa casing ena.
Ho jwalo, Your Worship.
Correct?
Would you agree with me, Colonel, that your investigations going forward may have a bearing on even the charges that are before this court?
Jale wena o tadimelana le nna ha ke re diphuputso tsa hao ha ntse di ya pele di ka nna da ama le diqoso tsena batho bana ba qoswang ka tsona mona.
Ho jwalo, Your Worship.
That's correct.
That in fact, already you did a preliminary investigation. And with that investigation, it revealed that the prosecution may proceed and prefer a charge of murder against accused number 1 in particular.
And wena o itse hape hona le diphuputsonyana tse tsa sthatong so sentse o di entse. And diphuputsong tseo wena o fumane hore motjhutjhisi kapa botjhutjhisi bo kanna ba kenya le qoso ya polao kgahlanong le moqosi wa pele.
But that was never said.
Mr. Court, pleases Your Worship. I don't believe my question was kept correctly. I said in the preliminary stage of your investigation, I put it to you. In the preliminary stage of your investigation, I did not say he testified to that effect. Perhaps I'm calling upon it. I can rephrase, Your Worship. It's not.
Yes, but even then, there is no charge of murder currently.
Your Worship, it is common cause. It is common cause, and my colleague withdrew the charge in court, placed it on record that there was a charge of murder, and withdrew it. And that is what I'm getting at, Your Worship. I don't know what prejudice there could be. Fact of the matter is, there was a charge of murder preferred against accused number 1. Subsequent investigations ensued, and that charge was withdrawn. It was withdrawn in court when we started with the bail application. I do not know what the state is coming to, Your Worship.
Yes, what the public prosecutor is trying to establish is to the relevancy of the anticipated charge being put back. That is one of murder against accused number 1.
No, Your Worship. That is not what we are saying. In fact, the relevancy here comes to the fact that there's outstanding investigations, and initially, there were preliminary investigations. Those investigations led to the state preferring a charge of murder against accused number 1. That is a fact. Further investigations ensued, and those further investigations that then ensued, led to the state withdrawing a charge of murder. And that is a fact, Your Worship.
Okay, perhaps just to rephrase the way you have put your question to, or your statement to the witness.
As the court pleases.
Thank you.
Colonel, in this matter, you have made certain investigations. Is that correct?
Sheba Colonel, casing ena hona le diphuputso tse itseng tso di entse. Okay.
Ho jwalo, Your Worship.
That's correct.
And in those preliminary investigations, you agree that the accused persons, and in particular I'm talking about accused number 1 now, were charged with certain charges that were preferred at that time. Is that correct?
And the puputso tseo tsa sethatong tseo e neng dipuputso tsa pele itse ka morao re di etsuwe yaba bakusiwa ba qoso ka diqoso tse itseng haholoholo ke buella mokusiweng wa pele o ne a qosiwa le ka meda bana mo.
That is so. Subsequent to accused number 1 being arrested and charged with, amongst others, murder, you did further investigations. Is that correct?
And ka morao re accused number 1 a tshwarwe and ele hore dikosong tseo a tshwarelang tsona la kapa tsa shebaneng le tsona ho na le ya polao hara tsona ho ile ba le diphuputso tse ding hape tso di etsang. Okay. That's correct.
And it is in these subsequent investigations that you realize that the murder charge will not be sustainable as at this time.
Ke diphuputsong tseo he tse tlileng ka morao mo o ile wa bona hore koso ya polao yona ha ena khona ho ema.
Is that statement correct, Mr. Moruri? Is it him who decides on what charge to be preferred?
Your Worship, I can rephrase that question.
Thank you.
Mr. Court, please. In the subsequent investigations, Colonel, that you, I accept, would have presented, did you present the findings of your subsequent investigations to the state prosecutor?
Okay, ka morao re wena o etse diphuputso tse ding o ile wa fana ka hore na wena o fumane eng mo diphuputsong tseo o fana ka sephetho sa hao ho motjhutjhisi? Yes, I did.
And is it thereafter that the prosecutor decided to withdraw the murder charge? Or in your opinion?
O ya ka mokgwa wena o nahanang ka teng ke ona ka mora sephetho seo sa hao ro fang ka sona motjhutjhising a ileng a nka qeto ya hore yena koso ya polao ha sa tswella ka yona. That is correct.
So you will agree with me that your investigations, as they go on, in fact, as they have progressed, have also had a bearing on the charges that is preferred before against accused number 1 and 7.
Jalo dumelana le nna ya ke re diphuputso tsa ho ya ka mokgwa di tswelletseng ka teng di ile tsa ba le ka mokgwa di amang diqoso tse le hore mokushwa wa pele le wa bosupa ba shebane le tsona. I do.
Colonel,
before you proceed, I think the wording might be ambiguous. I'm not sure. When you say the continued investigations do have bearing, what bearing?
Well, Your Worship,
negative bearings, positive bearings, what bearings? Because that word may connote something else. What I'm trying to say is that your questioning or your statement must be clear, because the wording might be ambiguous in a particular way.
Perhaps to clear it out.
Yes.
And in this particular regard, your investigations, in short, your further investigations led to the state withdrawing what I am going to argue to this court was the most serious charge preferred against the accused number 1, which is the charge of murder.
Are botse tsena e kena dipuputso tsa hao tse tswelletseng di ile tsa bakela hore state ba qhala case e nna ke tlontshang ngisana hore ine le yona e leng hore ke yona empe ka ho fetisisa mo dikosong tse le hore batho bana ba shebane le tsona. That's correct.
Now, Colonel, you testified as to how accused number 1, and I wish to refer to him, Your Worship, with your leave as accused number 1, and where I refer to applicant number 4, I'll refer to him as accused number 7, perhaps just for it to make sense in my head. I apologize if the court so wishes for me to do so.
Without necessarily directing you as to how you elicit your evidence,
Yes.
wouldn't it be prudent perhaps to deal with applicant number 1?
Yes, Your Worship. No. I was just saying that I will deal with applicant number 1, and that is how I have it. And once done, I will then go to applicant number 4. But if I happen to use the words interchangeably, applicant number 1, I may refer to him as accused number 1
Okay, no,
interchangeably if the court is satisfied with that.
Yes.
You testified, Colonel, that there are certain investigations that you conducted, and those investigations led you to linking accused number 1 in particular to certain actions within this alleged crimes.
Sheba o itse wena o ile wa ba le diphuputso tse di etsang ene diphuputso tse di etsang di ile etsa hore wena ho be le ka mokgwa o wena o kenyang accused number 1 casing ena ka teng. That is correct.
And Colonel, without going into much detail, I can put it to you that accused number 1 will at the right forum come and dispute all that you have put against him.
Ona le ha ke sa e haololo ka botebo ke batla ho jwetsa tjena e Kenya accused number 1 eo ha ho setse a fuwe monyetla le yena hona le mo apakanteng o tlo di hana kaofela dintho tseo wena o reng o di entse tlolong ena ya molao.
Ke sentse ke eme hore ke di bopaki bo ke faneng ka bona ke se wa sitse.
I still maintain that the evidence that I provided here is just what he did.
Colonel, you'll agree with me that the evidence that you provided here is not first-hand evidence. In fact, it is what you have learned from your will-be, or what the people who would be state witnesses when the matter proceeds.
Sheba ke na le bona bopaki bo wena o tlileng ka bona mona se bopaki bo eno hore bo tswa ho wena ka mokgo wena o boneng dintho di etsala ka teng. Ke bopaki bo bonkileng dipaking tseo ho ka etsalang di tle mona casing ena di tlo paka.
Ke bopaki bo ke bo thotse di witnessing, Worship.
Yes, it is indeed the evidence that I obtained from the potential witnesses.
And you will agree with me that those witnesses that you are mentioning now are not before this court.
Yes.
And in fact, for any determination to be made on their credibility by a court of law, they would have to come and testify.
And already now she will now back separate the local by to bow, but I may have bad them when about to back. That is correct, they are indeed going to come.
Colonel, I want to take you through your testimony in as far as it links accused number 1.
Accused number 1
and I will also touch upon what I am instructed to be pitfalls in your investigations.
And answer ke etsa jwalo ke tla nna ke nopola mo ho thweng wena o entse phoso teng diphuputsong tsa hao.
You testified that accused number 1 was a supervisor of the EST unit. Is that correct?
When I baki ba o itse accused number 1 in a supervisor mo unit ya EST. Kenneth? That's correct.
And that the duty of the EST unit was to, I want to quote you verbatim, the court would indulge me. Keep a lookout on the offenders, amongst others.
Well, we just meet EST nelo bashe bebakate ba tshwaruwa haramisebetsi e meng ya EST. That's correct.
And I'm instructed, and I put it to you, that the EST does not work with simply guarding offenders. It is merely there for emergency purposes.
Ke go bolela ke jwetsitswe eng and ntho eo e ke jwetsitsweng ke fa yona ona jwale hore EST ha e sebetse ho shebana le batshwaruwa. EST e mo bakeng sa maemo a tshwanyetso.
Do you have a comment on that?
Na le tshwaelo ntho
Ke tseba ba kata le batshwaruwa e boshika. The way ke fumane ka teng.
The way I found it through my investigations, they also guard the prisoners.
Colonel, you testified that accused number 1 was dismissed from his employment. Do you know when he was dismissed?
When I was we say accused number 1, we there a little who I'm sitting high, what's about now, on a little meaning.
Worship sa fosi ke sa re ke di 29 tsa September 2022.
If I am not mistaken, I suppose it was on the 29th of September 2022.
And you also testified that the witnesses that testified, or rather some of the witnesses that testified in the disciplinary hearing, would also be testifying in this criminal trial. Is that correct?
We now pakile hape hore dipaki tse ileng tsa paka mo disciplinary hearing e tlo ba dipaki hape mona nyeweng ena ha e setswela. That is correct.
And you will agree with me that the disciplinary hearing took place at least over 6 months ago.
That melana nna ha ke re he disciplinary hearing eo e la etsala mo dikgweding tse 6 tse fetile. That's correct.
I did not hear you testify that any of these purported witnesses have indicated that accused number 1 threatened them or tried to influence them in any way.
Haka utlwa wena o ntsha bopaki mona bo reng accused number 1 o ile a leka ho tshosetsa baki feng kapa efeng ho ba sentseng ba pakile kapa a mo beya bophelo ba hae ka mosing ka mokgwa o feng kapa o feng. Yes, I did not testify to that effect.
And for completeness sake, is there such a witness who said they fear for their life that testified against him at this hearing?
Hore ntho e felle ho la le paki jwang e reng yona e tshoseditswe ha sale e pakile go hearing you jwale bophelo ba yona ga go se bole kotsi. No, there is no witness. There is no witness who's claimed that.
But you testified that you have an apprehension of fear, or a fear that your witnesses may be interfered with, influenced or threatened.
When I still paki ba hore onale tshabo ya hore dipaki tsena di kana tsa tshosetswa kapa tsa ka mo go di tshosetswang ka teng kapa tsa hlohlua moya tsa tshusumetswa ka mokgwa o itseng. Yes, that's correct.
What brings this fear about?
King e fan tshabo eo.
Dipaki tsa mmuso hore di ka tshosetswa ke accused number 1.
I have a fear that the state witnesses might be threatened by accused number 1.
Put it to you, Colonel, that accused number 1 has already said under oath, that is evidence before this court, that he will not interfere with your witnesses.
Accused number 1 sa buile ntho eo. A bolela le khotla hore yena ha hona ka mogho wa ka a tshosetsang dipaki ka teng. Go ha hona ka mogho yena a tlo itsunyang ho dipaki ka teng.
Ka mehla di accused di tshwarwa le worship. Ho etsa le sona se se ba itseng ha se worship.
In usual instances, the accused persons always confirm that they will not interfere with the witnesses, but to the contrary, it turns out they do.
Are you now testifying that your view is based on your experience and not your investigations, Kenneth?
Jwale o reng wena o ya ntwena ya o hlahisa mona e ya ka bo phitlhelo ba hao mosebetsing wa ha esa le ntho e le hore e tswa diphuputsong tsa hao.
Ke tswang diphuputsong, Your Worship. Ke ne ke hlalosa se advocate ana se a se bolela ho.
That is based on my investigations. I was only expatiating on what you were asking me.
Colonel, you have testified right now that no witness said they were threatened. What in your investigations says they will be threatened?
Sheba o qeta hore jwetsa ona jwale hore ha ona paki e feng kapa e feng e itseng yona e tshoseditswe. Jwale diphuputsong tseo tsa hao tso di entseng ke diphuputso di feng tseo bontshang hore di tla tshosetswe.
Ke hobane information e ne ke fumane ho thwe accused number 1 ke motho ya linked le di-gang.
That is according to the information that I got. That informed me that accused number 1 has a link with the gangs.
And you did not find this prudent evidence to lead when the state prosecutor meticulously took you through your evidence.
Jalo bo fumana hore tlhahiso leseding eo ha e bohlokwa hakalo hore o ka hlahisa ha motjhutjhisi a ntse a o tataisa mo pakeng ba hao nakong e fetileng.
Ha ke ya ka botebo jolo ka ha motjhutjhisi ana itse ho nna ke hlahise fela link e bontshang bokosuwa le.
I did not go in depth as the prosecutor had guided me that I should only highlight how each accused person was linked to the crime.
Colonel, the final question from my learned colleague for the state to you was, do you have anything else to add? And you said no.
Ona potso o qetela he e leng ya botswa ke motjhutjhisi mo qetellang bopaki ba o teng ko re na hona le ntwe nngwe hape o batlang ho fitisa ho itsibisa aso botsing ka yona na wena o araba ore ai. That's correct.
Put it to you, what you are testifying now is nothing but an afterthought, Colonel.
Togo jwetse ntwe o re bolelang yona hona jwale ke ntho o qetang ho inahana hona jwale.
Che, ha o jwale.
No, that's not so.
Do you agree with me that the disciplinary hearing procedure impacted accused number 1's livelihood?
Wa dumelana nna ha ke re disciplinary hearing yana ilaba ya ba ka mokgo e bang le e amang boiphediso ba accused number 1? I do not know.
But you agree that if one is fired from their employment, they lose an income?
Fellow dumelana nna ha ke re motho ha le le ku mosebetsing ha sana le kene motho. Yes.
And for someone who, like accused number 1, has placed his personal circumstances before this court and indicated that he's a breadwinner, that would be a serious problem, would it not?
And jolo ka accused number 1 le nana sentse hlaisitse hore yena ke breadwinner mo a phelang teng. Ho lahlela ha ke mosebetsi o ka ba ka mathata nta.
Ki dumela hore nka etsa pele nka etsa ntho empe e leng kgahlano le molao jwalo ke dumela yena le motho ene tshantse o aware o feta batho ba a ke ba ina hanne hore ke tswe ke etsa di implications tsa yona ke di kamorao ho nna.
I believe when one is committing a crime or committing an offense that is against the law, like the accused has done, he would have considered the implications that would come thereafter, especially given the accused number 1 especially, how much more knowledgeable than other accused persons he is.
Colonel, please answer my question. And my question to you is, do you agree with me that someone who's a breadwinner losing an income, that would have a dire impact on their life? That was my question to you.
Okay, araba potso yena e Kenneth e go butsitseng yona. Ke ne go butse fela hore na wa dumela hore motho a nang le letseno ha a lahlelwa ke mosebetsi ho lahlela ho ha hae ke mosebetsi ho tlo ba le ditlamorao tse mpe bophelong ba hae.
Ho jwalo, Moshi.
That's correct.
And therefore, one would accept that such a person would have a reason to protect that interest with all they have. Is that not so?
Jwale ka moela motho wa jwalo a tsebang re tlo mo bakela mathata ntho eo a ka e tshireletsa ntho eo ya lekeno le la hae ka ntho engwe le engwe a nang le yona. Ha o jwalo?
Ha ke tsebe, Moshi.
Well, I do not know.
I put it to you that if accused number 1 had a reason or was a violent person, as you allege, you would have complaints that he has threatened somebody because he lost his livelihood. But he did not threaten anybody.
Sheba yena ntho ke bolelang yona ke hore ha bene accused number 1 ene le motho ana le dikgoka e ka be ho setse ho na le ditletlebo bona jwale hore o santse a batlile ho di etsa dikgoka tsa hae kae kae hona le matshosetsi kae kae ene ntho e jwalo ha e so ka etsa.
Ha ke tsebe, Moshi.
I do not know.
Well, Colonel, with all due respect, you're not here to testify about what you know. You're here to testify about what your investigations have led you to believe at this current stage. Have your investigations indicated that? That's a yes or no question.
Sheba ya kenela wa mona ka hlompho e kgolo ha wa tla mona o tlo o ntsha bopaki ka ntho e tsebang o tlile mona ka o tlo ntsha bopaki ka dintho tse di fumaneng diphuputsong tsa hao jwale diphuputsong tsa hao di o file yona ntho ya hore motho na o di kgoka ke potso ya hao e kapa tjhe
Ho jwalo.
That's correct.
Colonel, did you, and you testified that you looked into the criminal record history of accused number 1.
When I was about history, I had to the record sides, the criminal, okay? That's correct.
Does he have any criminal record whatsoever?
Well, criminal record, no, he has none.
Do you accept that the only indisputable proof that you could bring to this court that accused number 1 is a violent person is if you are showing that he has in the past engaged in violent activities?
So I don't know bopaki bono bo tla hlaela ka pele bo bontshang hore bo ka se phisiwe ke mang kapa mang hore accused number 1 ke motho a di kgoka ke motho a violent nkabe e le bopaki bo fumaneng di criminal record tsa hae. I do not know.
I'll leave that for argument, Colonel. Now, you further testified that there was money coming into accused number 1's account. And this money was coming from a certain TK. Is that correct?
When I talking about we say no na le ditšhelete tse ntse di kena accountong ya accused number 1. Ene di pa go ditšhelete eo ene le tšhelete e tswang mothong o tweng ke TK ke nnete. That's correct.
Was the only identifying feature of the payment or the payer, the initials TK? Was that all? Did it have a surname?
Sheba ka mokgwa bona o no bona ka teng kapa o fumaneng ka teng motho eo ntseng a patala o tswe ke TK o na hlahella fela ka TK eo fela kapa o nona le fane mo
o na hlaga TK.
This individual was only identified with those initials TK.
But you testified that TK, you believe TK to be Thabo Bester because he sometimes has aliases. Is that correct?
When I would say o khola hore TK ena ke Thabo Bester o ba Thabo Bester o na le mabitsonyana a mang ha ba ipitsang ka ona. Correct?
I put it to you that TK can mean a variety of things.
Toko jwetse Colonel TK e ka bolela ntho tse ngata.
The first one, TK could simply be anyone whose name starts with a T and the second name is a K, initials. You accept that?
Ya pele, TK e kana ba motho e mong le mong fela a nang le lebitso le qalang ka T se name ya hae e le K. Wa dumelana le? I do not agree with you.
In fact, TK could also be a nickname.
And I bet TK can have a nickname, if I do not know.
We will deal with the suspect at trial.
Well, the two that is
You testified, Colonel, that accused number 1 was acquainted to the deceased in this matter.
Ntongo ya po ntse bopaki ka yona ke hore accused number 1 o ne a tlwaelane le mofu a hlaelang mona case ena. That's correct?
For the seats, I do not intend stopping you. We did not initially talk about some Harv's rules in terms of moving forward with this matter in terms of the lunch and the like, because I see now it's lunchtime unless we agree that we proceed throughout lunch. I just wanted us, just before he gets into details with this question, pardon me, that we make that determination.
Thank you for alerting us in terms of time.
Yes,
Yes, Mr. Mururi.
Your Worship, I do not wish to sound selfish, but I'm on my feet, Your Worship, and if my colleagues are with me, then we can proceed until such a time, perhaps, that one of my colleagues would indicate their discomfort. I'm in their hands, Your Worship, and of course, your more than capable hands, Your Worship.
Yes, let me hear from the individuals. Yes,
Yes, Your Worship, I don't have a problem if we proceed, maybe for an hour or so.
Certainly 1 hour more won't do any harm, Your Worship, if you please.
Is it please? I concur. Let's proceed, Your Worship.
that, okay. Does that tend to suggest that lunch is taken later or we proceed through with no lunch?
I believe, and I do not want to speak on behalf of any of my colleagues, but perhaps a 15-minute adjournment at 2 o'clock just for a break, comfort break, and we are back in court.
Okay.
I agree.
Okay.
Then
Then agreed. Yes, you may proceed. Then,
Yes,
Mr.
Your Worship, you did not indicate your view, but I accept that you are with us.
No, let's proceed.
Colonel, you testified in depth about where the deceased in particular was found, and I don't want to go into that much detail.
Bona e kete lona hore boleletse ka botebo ya hore na mofu o ne a fungwana kae empa mothating ona ha ke batle ho kenella holoholo dintlheng tseo so so buile ka tsona.
Sorry,
In particular, and I'm clearing it out, Your Worship,
Yes,
in
yes.
particular, where he was found at the taxi rank and then taken to the hospital.
Ha o le jwang haholoholo mo no o fumane teng taxi renkeng ya ba o nkuwa o isiwa sepatala.
Okay, Mr. Mururi, sorry to interject. I did not do justice with the earlier request that was made.
Yes, Your Worship.
May I establish, please, with other court officials?
Oh, yes,
Thank
yes.
you.
And my apologies, Your Worship.
Thank
I
you,
apologize
thank
to
you.
my colleagues.
And I also apologize for having let the matter be proceeded with. Mr. Manyosi, let me hear from you. Is it in order with you for matter to be proceeded with as suggested?
Yes, so she's saying that with the action is already in momentum and we don't want to break that, and we know the agency of this matter.
Yes.
Yeah,
We
don't
would-
elaborate
we would-
too
we
much. Then thank you.
The court order will also bring one thing to my attention. Perhaps my learned friends can clear it up. That we should consider that 1 o'clock is also lunchtime, where the awaiting prisoners are also fed. So it should be established, if they don't have a problem, that they can be fed later.
Yes, Mr. Morori. Inclusive are your clients. Apparently, during lunch period, they must have access to food, your clients. You may establish, perhaps with your clients, whether it is in order to proceed with them without having access to food.
May I turn my back on this?
Yes.
Maybe
And-
more closer.
yes, yes.
Mine says your finish.
Your Worship, I am told to go full steam ahead. I have just established or ascertained from my learned colleague from SAPSI indicated that they will reserve a meal for them, so we can proceed, Your Worship.
Thank you. For as long as it is agreed.
I think
you.
I speak for all my colleagues.
Yes, that's right.
Yes, I've already got a confirmation from your colleague.
As
You
the
may
court
proceed.
Now I seem to have lost my bearings, Your Worship. If the court would just indulge me for one
Yes.
second. Yes. Colonel, you indicated that the deceased was then taken to hospital, and that is where I'm going to leave it.
Wena o ile wa re pakeng ba mofu o ile a nkuwa a isiwa hospital. That's correct.
Do you have a post-mortem that indicates the cause of death of the deceased?
Well, postmortem e bontshang hore na mofu o bolawa ke. Yes, I do.
Would you enlighten us?
O ka re hlahisa leseding?
Yeah, Mr. Murori, I'm trying to think as to what relevancy will this be, because there is no charge of murder. I know there was a reference to the murder.
Yes, Your Worship.
But I'm not sure where are you stretching it.
Your Worship, if the court would indulge me, it will become very clear in the next two questions.
Okay.
Mr. Court, please.
Yeah, o ka hlahisa leseding ya that ka postmortem ena hore na mofu o bolawa ke.
Postmortem report ne itse mofu hana hauna smoke inhalation ka matshwafong a hae.
The postmortem report indicated that the deceased had no smoke inhalation in his lungs.
Hape una na le fracture hloho.
It also indicated that he had a fracture on his head.
Did you establish the cause of the fracture?
Wena o ile wa fuputsa hore na keng e entseng hore motho a fracture ya hlooho?
Hono le diputso santse di tswela pele o tla ba boima ho nna ho e hlalosa.
Well, the investigations are still underway, so it would be difficult for me to explicitly say.
Okay, I accept that. But you are investigating the cause of this fracture.
Empa wena o santsane o ifuputsa taba hore na ho tlile jwang hlooho ya motho e fracture. Yes.
Colonel, you testified that the deceased, in accused number 1, would just one second, drink together, I believe are the words that you used.
Wala o ntse o pakeng ba ha hore accused number 1 le mofu ne ba ne ba ka ba nwe mo.
We have information e ke fumaneng ho she.
That was according to the information I obtained.
Put it to you that accused number 1 will come at the right platform and say he does not know the deceased in any way.
Togo jetse ha a tla ena accused number 1 a tlo ipakela mona ha so tshwanelele a paki o tlo bua hore yena ha a tsebe mofu ho hang. Well, I do not know that.
What do you not know, Colonel? Do you not know if they knew each other, or do you not know what he will come and testify?
Ke o sa tsebe taba o sa tsebeng ke hore ha batho ba tsebe taba hore ba ne ba tsebana kapa o tsebe taba hore o tla a tlo paka a re
Ha ke tsebe o tla tlopa ka re, Your Worship.
I do not know what is it that he is going to come and testify.
But you will agree with me that you personally do not know if accused number 1 and the deceased drank together. It is what you are informed of. Someone else once more.
Empa dumelana le nna ano hore wena ka boena ha o tsebe hore ba ne ba nwa mmo ke ntho fela o utlwileng batho.
Ke lesedi le ke le fumane motho, Your Worship.
That is the information I got from other people.
Colonel, when you say your information, did it say where they used to drink together?
Well, se le ha lo jwetsitse he hore na bana ba nolla kae mo.
Che, Your Worship.
No.
Do you perhaps have a specific date on which they were seen drinking together?
Yo mhlobo na le date mhlomong it's a pameng mo bana ba bonwa banwa mo.
Agena date, Your Worship.
No, I do not have a date.
So you do not have a place, nor do you have a date, but your information says they used to drink together.
Jalo wena ha ona date, ha ona le sebaka se bone ba nolla teng, empa le sedi lo fumaneng ke hore batho ba bane ba nwa mo.
Ho jwale, Your Worship.
That's correct. Put it to you that accused number 1 has never drank with the deceased at any tavern, club, pub, or any other place of that nature.
Toko jwetse he. Accused number 1 ha asoka anwa le mofu. Taverneng e feng kapa e feng, clubeng e feng kapa e feng, kapa kae mo ho nwang jwala teng.
Ke a hanana le ho ya ka information ho thwe banwa more vitamin.
I dispute that. According to the information I have, they were drinking together at the taverns.
Colonel, we have already established on your own evidence that this information you have does not have a date or a time. So I will reserve that for argument.
Well, ke tlangisana ka na since re fana ka di argument tsa ro. Ka go itse wena ha ena date ntwe ha ena le na.
Colonel, you further testified that, perhaps let me put it to you in this way. Now I'm touching on my colleague's client, but it will bear no prejudice. Accused number 2 testified in this court under oath that he received a call. Accused number 3, my apologies. Accused number 3 testified in this very court that he received a call from the police. And the police invited him to Mimosa Mall. I put it to you.
Toki hatate hanyanyana ho client ya colleague ya kana ke kholo ntwe e tla mme ka mosing ka mogwa o itseng. Accused number 3 yena o itse o fumane call o tswa leponeseng. Are leponesa leo le be le mo memela hore ba kopane le Mimosa Mall. Ke ntwe go jetsang yona eo.
Yes.
If I may get clarity, is that what his affidavit says, or is it like my learned friend, he testified here in this court? I can't remember him testifying as such, but there was a statement under oath read on his behalf that states that. If that can be clarified.
Your Worship, testimony, statement under oath, it's all evidence before this court. If my colleague so wishes, I will withdraw the word testify and say he placed it under oath before this honorable court.
Well, we buile tasakano to go we beile tasakano to mona le hotel lena hore yena o ile a fumana kholo tswa leponeseng leponesa leo le be le mo memela hore ba kopane le Mimosa Mall.
No, Worship. Tsebo ke na le yone ke ho Mokosua ke yena a founetseng lepolesa hore o batla ho kopana le lepolesa la le tshepang a tlo kopana le lona Mimosa.
But the information that I have was that the accused person was the one who made a call to the police officer, saying that he wanted to have to meet with the police officer that he had faith in, and that he wanted to meet that particular police officer at the Mimosa Mall.
But you agree that what you are testifying and what the accused number 2 placed under oath before this court are in conflict?
Jwale wa dumelana na ke ntwe buang ka yona ya hore ntwe o testify ona jwale le ebe ena e beile mane ke ntwe tse thulana.
Le nna ke na le statement under oath sa lepolesa le no bua le ma bolela ho Mokosua ke yena mo letseditse a go batla go kopana le lepolesa la le tshepa wa kopana le Mimosa.
I also have a statement that was taken under oath by the police officer, where the police officer reports that the accused person was the one who made a call to him and said that he wanted to meet a police officer that he could trust, so they could meet at the Mimosa Mall.
Yeah, Mr. Murori, I thought maybe you will get there soon. I just want to check with you what accused number 3 said to this court through the affidavit. What does that has got to do with application of accused number 1?
Well, Your Worship, certain averments were made that accused number 3 indicated that he fears for his life, and part of the people that he fears for his life from would be part of the co-accused. And what I'm trying to establish here is that clearly, from the get-go, there's a conflict between the first version that we got in this court, who called who. There's a conflict there. And my end goal is to put it to the witness that there will be conflict even going forward.
Yeah, just go straight to the point.
So court pleases.
Yeah, refrain from circumlocating on the aspects that is already before court. Go straight to the point.
As the court pleases.
Thank you.
Sir, I put it to you that accused number 3 has already testified as I've informed you. And in fact, he did not make that telephone call, nor did he say that he feared for his life.
Accused number 3 sa beile bopaki ba hae ka pela lekgotla, and ha ona mo a itseng o tshabela bophelo ba hae, and ha ona mo e leng hore ke o itse ke le posa ke lona le mo founetseng ntho eo se bile e fapana di tlo wa fela.
I'm not sure whether you are the mouthpiece of accused number 3.
Your Worship, with all due respect, that is a statement that is uncalled for. And with the greatest of respect, I'm not wishing to be anyone's mouthpiece, Your Worship. What I am doing is leading my client's evidence. It is said before this court that accused number 3 feared for his life. He made an affidavit before this very court. He did not mention that. And that is what I'm putting to this witness who says accused number 3 said he feared for his life.
Yes, but my understanding, your client is accused number 1 and accused number 6.
Indeed so, but if accused number 3 fears for his life against my client, but he does not mention it in an affidavit, and the police official who's testifying now says to this very same court that accused number 3 fears for his life, I'm trying to put it to him, and that is what I'm saying, Your Worship. I'm putting it to him that what he's saying is not correct, because the person who speaks for himself has not said that before this court, Your Worship. I do not see where the prejudice is, Your Worship.
Continue, Mr. Murori.
So court pleases. Do you have a comment on that?
Well, I don't know that.
Usually, ka tsa hae hore o a tshaba o tshabela bophelo ba hae le mofumadi wa hae ke nana hore a ka tla testify hobane o la ba raitsa hore a bue le yena a ba kopana le yena mo e le hore o na mo hlalosetse, ene kopong ya hae o na itse hore o kopa hore a kwallwe police kore dislabeling a kwallwe hole le Bloemfontein hobane o tshaba o tshabela bophelo ba hae. Ho eda mono Yoshi le di fotong ha o ka sheba ha na lo etsa pointing out o yentse pointing out after emergency ya hae dimo a re ha a batle le hore le di-colleague tsa hae di mo hobane wa tshaba o tshabela bophelo ba hae.
And these are photos that are not before this court.
Can that be interpreted
Oh,
for the next
apologies.
question? Yes, please.
Well, Mr. Dipulo did mention that he was fearing for his life. And he even requested to see his wife in order for him to come in order for him to explain that to his wife, that he was fearing for his life. And he even pleaded that he be kept in custody at a place away from Bloemfontein. And to top that all off, even when during the time he was pointing out, all the pointings out that he made, he was having a sweater wrapped around his head, and he was claiming that he didn't want even his colleagues to identify him.
I put it to you that they all shared a cell and no harm. That would be accused number 1 and 7 have shared a holding cell in this very same court and no harm befell accused number 3, and I'll leave it at that.
So one and also willing to a bonsang or Kabaliko teaching and by your head get a create allow say Arabi.
Unless you wish to answer.
Ke dumela tsebong ya ka yoshi moqosua le mo ba kwalletsweng teng ba fapane ka ditrongo ha ba sebakeng se le seng ke ka moo nna ke tsebang ka.
According to my knowledge, the accused persons are not held in one prison. They are not kept in custody in one place.
Yes, I was referring to the holding cell, and that is what I said here at court.
No, that is the same work at the holding cells. But when somebody holding cell in one more and it was not good.
Do you have a comment on that?
That's right. Well, I do not know about that. I am not working in the cells, in the holding cells.
Colonel, where was accused number 1 arrested?
Accused number 1 he was arrested at his abode.
Did he try to resist the arrest or flee from you?
Wile aleka ho han ho resist o tshwarwa mo kapa aleka ho bali? No, he did not do that.
And did he hand over his passport to you upon your request, or how did it come about that his passport is now in your possession?
Jalo o tlile jwang passport ya hae ebe wena we o fane ka yona ha o e kopa fela kapa ho tlile jwang ebe o na le passport ya hae wena? When I requested him to give me his passport, he handed it over to me.
What else did he hand over to you?
King about the
cell phone ya hae yoshi.
He also gave me his cell phone.
ID card ya hae yoshi.
He also gave me his ID card.
You say he handed over his cell phone. Did he also give you a PIN or a password to the cell phone?
Of the PIN, password, PIN. Well, I'm not certain whether he gave me a PIN or a pattern of a cell phone.
So would you say that he cooperated when you arrested him?
Yes, he gave full cooperation.
Colonel, you testified that from his passport, you glanced that he had 16 stamps in and out of the country, particularly into Lesotho. Is that correct?
But I would say, how about passport you have Fumano Onanza Kela Atwa Lesotho? That's correct.
And you said this amounted to 8 visits.
And then Toyo, we lay ha, Ebron Sitore, or Chakete, Lesotho 8. That's correct.
I put it to you that you are wrong, Colonel.
So what you say, Colonel? Opposite, Elhonamo.
In fact, at a port of entry, one gets 2 stamps to gain entry into a different country and 2 stamps to re-enter the country.
And then the more who can want the modi gating sale, modi border gating sale. Moto ha akena, ufumana di stamp tse pedi. O kena ka country nye. And le ha a khutlela country nye a tswang ka ho yona. Ufumana di stamp tse ding tse pedi.
Do you have a comment on that, Kevin?
Well, I agree with you on that.
Now, Colonel, you would agree that as...
Let me establish which part are you agreeing that you were wrong, or you agree with the part that 2 stamps when one exits and then when one enters, or do you agree on both parts of the sentence posed to you?
So what you say, Colonel? But now, do you mean on opposite? Kapa du mena taba ya hore motho ha kena fumana stepe tse pedi ha a tswa fumana stepe tse pedi kapa o dumela na tsona di le pedi tse tsa hore o no fositse e dile wa tseba motho o fumana stepe tse pedi ha kena le ha a tswa
kuri ke ne ke tlhalosa ka ra passport e worship hona le ditempe tse 60 tse bontshang hore wa bona hore ke departure e nngwe ke ki exit ya tswa ka mwana tswa teng jwale ine di ditempe tse 60 di boele ho ke ho bolela ke makgetlo a ka ba robedi mo mokoswana tse.
What I was trying to explain was that in the passport I saw that there were 16 stamps. That in some of the stamps indicated the departure and other stamps indicated the return of the person from the Lesotho. So that indicated to me that he made 8 trips.
So I put it to you that yes, there are 16 stamps on that passport, but that a single visit into Lesotho, one accumulates 4 stamps, 2 upon departing from the country, 2 upon re-entry into the country being South Africa. 2 into Lesotho, 2 upon your return.
Shabaka dumela hore ditempe tse hlahellang passport-ong eo di 16 empa ntho ke o jwetsang yona ka ditempe tseo ke hore ha motho a kena ka hara Lesotho ho tempuwa habedi a ba kena mohlang a khutlang ha khutla ho tempuwa hape habedi ho ga khutlele hape ka South Africa. That is correct.
And therefore 16 divided by 4 is 4. That means choose number 5 only went 4 times to Lesotho.
Jale ya arula 16 ka 4 ke e fa 4. Hobane ntwe e tlo bontsha hore o ile ha 4 fela ka Lesotho ntwe. Accused number 1.
I apologize, Your Worship. I referred to the incorrect accused. I'm referring to accused number 1.
Okay. What's accused number 1? Haven't o dumela ha kena o fuwa stamp tse pedi ha tswa o fuwa tse pedi e bolela hore o ile ha 4 hela o ile ha 4 fela
ho bolela kana ke nna ke ntse mphoso ka calculator trips.
Well, that would mean then I am the one who made a mistake by calculating each stamp as it would be per a trip.
To err is human, Colonel. It's not a problem.
Well, when it's a person, kinto is one kimang lemang, Colonel. I seem to
You also testified that the last time that there was movement on this passport, the last time that there's a stamp on it is in November. That would be November 2022. Am I correct?
When I was saying, "Loud ela how ne ona le ho tshediswa passport ena for tsamaya ene le ka November ka 2022." That's correct.
It was your testimony that accused number 1 has relatives in Lesotho. Did you investigate where exactly they are located?
When I was talking about accused number 1 and then the family ka teng ka Lesotho ka mo. O ile wa fuputsa he hore na di o kae family tse tsa hae?
Che, Worship.
I did not investigate that.
Put it to you that accused number 1 will come and testify before this court and say that he does not have any relatives that he knows of in Lesotho, but only people that he communicates with on Facebook because they happen to share the same surname.
Toko jetse accused number 1 na to bua hore na hana di family ka mo ka Lesotho ka mo. And batho ba abatsebang ka Lesotho ka mo ke batho ba ile hore ba kopane Facebookung ba ntsa bua le bona Facebookung le teng ka baka la hore bana le fane e tshwanang fela.
Nna le tshedile ne ke le fumane ele ne ke le fumane Worship o itse o na le di relative ka Lesotho.
But the information that I obtained, I was told that he has relatives in Lesotho.
In fact, he will come and account for each one of those trips. And I put it to you that the first trip was when he accompanied his girlfriend to a tombstone in Lesotho.
And then I would go to Mona Aba and Sawapaki Ba Horina tripping Emulem Unakana Kalsutu Kamoaluenza. Ile ore ya pele trip ana ya ana ile Lesotho ka na inele ha ana felitse girlfriend ya hae ina le tombstone ka mo. Well, I don't know about that.
And the remainder of the trips were to accompany boys to the initiation school.
And tsena tse ding di trip tsa di entseng ho kena ka Lesotho ka mo inele ha feleditse bashimane ho ya lebollo. I do not have any information to that effect.
I'm sorry, Colonel, I believe there's one aspect that I did not converse with you. You indicated that accused number 1 had access to the personnel files that had the address to to the people who could possibly be the state witnesses in this matter. Is that correct?
Bona gona le ntanyana le ksa e conversation. O itse wena bopaking ba hao accused number 1 ona ana le access mo di filing tsa batho ba bang bo ka tsalang ebe ke dipaki casing ena. That's correct.
I put it to you that accused number 1 will come and dispute that.
O tlota yena ba a phisa kaofela ntwe. I do not agree with that.
He will come and testify that those files are kept by Human Resource Department and he does not know any of your would-be witnesses' addresses.
Toko jetse yena a di file tseo di tshwadwa ke batho ba HR kwa. Ene ha tsebe le hore na ke bomang ba tlotlang e ba dipaki casing ena. I do not agree with that.
You, and we have already canvassed this, confirm that accused number 1 does not have any previous convictions. Is that correct?
When we say an record, that's correct.
And what you felt was the burning issue, part of it, for you opposing today's bail application, is the fact that the community is enraged. Is that correct?
And when I'm to baka le ka sehlohlolong le wena ka baka la lona o hanang ho ba fa bail batho bana ke hore batho ba setjhabeng ba kgenne ke nnete
le hape hore mokusuwa ha ka fumana beili ho ya ka case ka nyewe e kgahlanong le bona le di ka mokgo e etsaetseng ka teng e tlisa tshabo le tshono le ka hare setjhaba sena.
And the other thing is that if it can happen that the accused persons are granted bail, given the nature of the charges that they are facing. That is going to bring anxiety. It is going to bring fear in the community.
You also testified that there was a picket, and I accept it would have been on the 11th of May, because when you testified it was the 12th, and you said there were even people picketing outside yesterday.
When I say nobile na le batho ba ipela etsa mona kantle ka mona ba ntse ba picket ka di 11 tsa May. That is correct.
How many people were there? Do you know? Can you estimate?
I did not count them.
I'm asking for an estimate. 50, 100, 1,000?
Tikanyetso fela. Ke go botsa ka tikanyetso fela. Ba ne ba ka ba 50, kapa 100, kapa 1,000. I believe there were less than 50.
And you believe that 50 people can represent the view of the entire community?
Jwale wena o bodumela hape hore batho ba ka ba 50 fela ba ka emela maikutlo a community kaofela. That is so.
I put it to you that that is highly improbable.
Ha ona kgonahalo e jwalo he ntate hore batho ba 50 nyana fela ba be ba emetse maikutlo a setjhaba ka kakaretso.
Do you have a comment on that?
No, that's fine.
Ki dumela jwale ka ne se ke hlaloseditse lekgotla dipuo tsa batho le ka mokgonyeo ena e le medium ka teng bona ka ra khotwena ho tlile di-camera tse ka tsa di-different TV station. Ki dumela hore ka mokgwa ke tswena nyewe ena e tsaitseng ka teng e tshositse batho ene le ka mokgwa e le hore e entswe ka teng e tshositse setjhaba. That is why ke kopa ka pelo le kgotla ke ne ke re ha ba considere mabaka re fanang ka ona hobane ke tshabo e re tshaba hore ho ka tloha etsala ntho tse mpe bona KwaZulu Natal ho la etsala Senegal KC hona nna etsala ana ke madi a maka tshwantse a tswe before ka utlwisisa.
I believe, according to the talks of people and according to the nature of the charges that the accused persons are facing, and according to how those crimes were carried out, that has in itself shocked the nation. And you can take it from now. You can see how many cameras are here. And those cameras are from different media houses. They are from different TV stations. And you can take an example of what occurred in KwaZulu Natal. And you can take another example of what happened in Senegal. How much blood has to be spilled before we understand what's going on? I would then plead with them to reconsider this.
So you're saying in making its determination, the court must consider that there are cameras here today?
tshwaelo yena ya hao e nke le hloohong o batla court e nke tshwaelo eo hobane hona le di-camera ka moo
ntle le tello advocate worship ha se taba ya camera ke taba ya sapola motho ha re monana hore ke hatella mang kapa ke nempa ke maikutlo le tlhahiso e ke ntshang hodima investigation e ke entseng.
Without being disrespectful, notwithstanding that there are cameras here, my view is not about that. It is about the life of a person. What's up? Okay. I was only airing out my views, and I am not being repressive to any person's views.
Sir, you also, and perhaps let me deal with this aspect. You will accept that each case that comes before this honorable court must be dealt with on its own set of facts and merits. Is that correct?
I agree with you.
And you'll also accept, I do not know which specific matter you're referencing as far as KwaZulu-Natal or Senegal is concerned, but those matters, as you mentioned them, are not before this court.
And I bet the thing they were now or KwaZulu-Natal and Senegal, and it happened. The case is still has to not tell you or Yes, I agree with you.
Colonel, you confirmed the accused address, but you also indicated that is accused number 1. But you also indicated that there's another address, and this is the address that appears on the registration certificate of his car.
So what do we say? Will I confirm address? I empa obobua hore honale address ye nngwe e leng e hlaellang mo registrationeng ya koloing ya hae. Yes.
Colonel, I put it to you, well, you further testified, and my apologies, Colonel. You further testified that the address, upon your further investigation, you discovered that it was accused number 1's sister's place of residence.
When I say I also do if we ya pele address ye we ya bobedi in the address e le hore ke has OCWA accused number 1. That is correct.
So in essence, you confirm that accused number 1 has an alternative address.
Jalo ka mantswe a mangwe ntse o netefatsa hore accused number 1 o na le address ye nngwe a ka dula mo alternative.
Bothata hore nka e hlalosa hore a ka dula teng hobane ha ke tsebe maikutlo a shwa.
Well, it will be difficult for me to confirm that he could stay at the said address because I do not know what his sister's views are.
Finally, Colonel, you testified into money that moved from accused number 1's account to accused number 3 and also to accused number 7. I put it to you that accused number 1, at the right forum, explain the reason for those transactions.
So when I would still pay money about the honali chelete in the accounting ya accused number 1, accounting ya accused number 3, the accounting ya accused number 7. That was just a general Kenneth. How is it to money lemon yet or but accused number 1 abu or what I was or na in a detail that I see.
Do you have a comment, Kenneth?
Well, let's try Lomo.
Ke sentse ke ema mantsweng a ka hore jwalo ka ne ke kwa tšhelete tseo ke tse tswang ho TK e le hore ke TK kwana ke santse ke ditse mantswenyana o tla tla ka bopaki ba hae ha ke hanyetsana.
Well, I still maintain what I previously testified about, that those monies were coming from TK Nkwana. Well, he can come and testify whatever he testifies, but I stand by what I initially testified about.
Beg the court's indulgence, Your Worship. Perhaps one final aspect that I wish to converse with you before I turn my back on this honorable court with its team. You indicated that the accused, well, members of one Bloemfontein Celtics were not really happy and wanted the accused number one in particular, now that we're dealing with him, not to be granted bail. Is that correct?
So when Ronaldo we think the supporters are Bloemfontein Celtic in this Taba or Hang in this Sabatle or accused number one Joloka I consider basically ask about a fuman to be. Kenneth.
Bonjour, Worship. It seems fela accused number one. Bane ba bolela batho ba shebaneng le qoswena. Ke dumela haebe advocate tuna shebile le TV ka Sontaga. Pule Mabena e le reng ke pro ya Celtics ya di-supporter. O entse phatlalatsa ho mang le mang. Jwale ke yona ke tjho ke le balatedi ha ba kgotsofala.
Yes, I agree with you, and that did not go just as far as accused number one was concerned. Every person in here, all the accused persons who are facing these charges, the community is against their release on bail. And if the advocate was watching TV on Sunday, I believe the advocate will have seen that Pule Mabena, who is the PRO of the Celtic supporters, said it explicitly that the supporters of Celtic members of Celtic Club are not happy and they do not want the accused persons to be released on bail.
Do you know if Bloemfontein Celtic still exists?
It was Bloemfontein Celtic in the EP. It does not exist anymore.
So we are talking about supporters of a team that doesn't exist.
We are supporters that team is happening in the day.
Supporters the Celtic City highly siko banze ba support. Even le club ha ke support desire ke Marumo Gallants. Ntse ba support supporters tsa Celtic.
Even though Celtic does not exist anymore, but the Bloemfontein Celtic supporters are still supporting soccer, and there is even a club called Marumo Gallants that the Bloemfontein Celtic supporters are rallying behind.
And I don't want to belabor this point. Perhaps two more questions on it. Do you know what the fan base of Bloemfontein Celtics was? How big was this fan base in its heyday?
Ona e sa sa go le a go ntla ena wa gopola to the fan tsa Celtic ko fan base ya teng ne le golo ha kae kae. Yes, I know.
And you testified that Celtics fans were picketing here on the 11th of May.
And when out on still pa ke mona ba gore di fene tsa Celtic ne di piketa mona ka 11 tsa May. That is correct.
How big was the fan base?
Ho na le difene tse kae ka mo?
nakong ya khoto e kene.
Do you mean when the court was in process? Well, in process. When the court is proceeding?
Through you, Your Worship. Well, I'm asking when you saw them.
Ke botsa kana go wena o no ba bona.
Ke bolela hore ke se kile ka wa re ke estimate ke itse ke ka tlase ke show 50.
Well, you told me to estimate, and I told you that they could have been less than 50.
And how big was the fan base? The Bloemfontein fan base in general. You can estimate. I don't expect you to be spot on.
Well,
give or take, could they fill a stadium that carries 10,000 people? The Celtics fans themselves.
Okay, but the supporters of the local akae. Last la ko ke batla fela we lekanyetsa fela la sa be accurate. Ine ne ka etsa ne ka tlatsa stadium sa batho ba 10,000. That's correct.
But only 50 showed up.
Imba ba 50 nyana fela ke bona ba fihlile mona ba picket.
Ke dumela ke ba nile le bogodi ba o tla kwana khoto.
Well, I suppose those were the ones who were able to make their way to the court.
The court pleases Your Worship. May I turn my back on the court?
Yes, Mr. Mururi.
Your Worship, just one aspect that I'm instructed to converse with the Colonel. Colonel, I'm instructed that when you arrested accused number 1, you found documents in his car, and those documents were for the Department of Labor for UIF claims. Is that correct?
Colonel, ke blelwa mona ke accused number 1 mona hore wena ano motshwara. Ka kolonya o fumana le tokomane mo ile tokomane tsa labor ile tse hone ho lo claim wa UIF ka tsona ke nnete
Ditokomane tse ke di thotseng e ne le tsa registration ya koloi ke yone ne re kopa koloi e register le mabitso a mang.
The documents that I found there were those of the car registration. It was when we were requesting him to give us the documents in order for us to see in whose name was the car registered.
Were there any other documents?
Unana tse ding hape ditokomane mo?
Wila mkusiwa ke na ilare o tshwere dipampiri tsa UIF ke yona direction.
The accused person told us that he had the UIF documentation with him.
Did you try and satisfy yourself to see if indeed those were UIF documents, or did you accept his word?
When I will lewa ipotsofatsa o di sheba hore ka nnete ke tsa UIF kapa o nkile fela ntho a bolellang yona ka botsa maka yona.
Ke nkile fela ntho ya bolellang yona.
I just took his word for it.
So you cannot dispute that he is busy attending to a UIF claim.
Jalo wena o ka se hane taba hore o ntse le busy a ntse a lokisana le claim ya hae ya UIF. Well, I do not know about that, and I would not comment on it.
As the court pleases, Your Worship. Your Worship, that would then be the cross-examination on behalf of accused number 1. And I see we are a minute before the proposed adjournment time, so I'm right on time, Your Worship.
Yeah, no, thank you. Thank you for that, Mr. Mururi.
As the court pleases, Your Worship.
So, If we adjourn, at what time must we resume?
This time, Your Worship, I'll let my learned senior colleagues advise the court.
Okay, let me start this time from the defense. Mr. Makameli.
I thought that we said we would adjourn for about 15 minutes and come back. I thought that was the initial agreement. So if we'd stick to that, that would be much appreciated.
Oh, you say 15 minutes?
Yes.
Meaning we must come back at 2:15?
Yes, that's what we alluded to before.
Mr. Kwenan?
I concur with my learned colleague.
Confirm, Your Worship.
Official, Mr. Manyuzi?
Yes, with me it's different. You know, other people are just taking notes. With me, I am actually working, so I'll request a longer time than that. Maybe 20 minutes or, in fact, I would request for 30 minutes, Your Worship. But I don't know whether it
Request
will be.
30 minutes, okay.
Yeah.
Madam, any time is fine with that. Mr. Matuku?
No, I just also wanted to indicate that the court orderly indicates to me it might take them around about 20 minutes to prepare and feed the applicants before continuing.
So 30 minutes is appropriate.
I suppose, yes, thank you.
Okay.
Then that will be 2:30.
2:30, okay. Court adjourns until 2:30. You are still under oath? Thank you. Okay.
2023, state against Noe Matswara and others. We are all ready. Yes. Thank you.
I'm on my feet, Your Worship. I'm not so sure as to whether the court would let me proceed on behalf of accused number 3, the second applicant, or the court want Mr. Mururi to proceed on behalf of 1 and 7 in this case. I'm not so sure.
Yes, I think it will make sense because evidence in chief, I think it was in such a sequence. I actually intended to allow Mr. Mururi to proceed with his cross-examination even in respect of accused number 7. If you are ready to do so.
Your Worship, if my learned colleague could kindly proceed, there's just certain aspects I do not want to delay the court on. There's just certain aspects that I need to go through quickly. My colleague, may proceed with your leave, Your Worship, and I'm indebted to you.
Then it's fine with me.
No, thanks, Your Worship. No.
Okay, before you proceed, Colonel Flyman, you are still under oath, bound by the oath that you earlier took.
Yes, sir.
Thank you.
Thank you. Colonel Flyman, good afternoon.
Good afternoon.
You know that bail proceedings are sui generis of their own kind, and their main concern is for the liberty of an applicant, and this is a right that is enshrined in the Constitution of the Republic of South Africa, right?
What's about it to baby? Yona mokgwa yona ka mokgwa e leng ka teng ke taba ya tokologo ya batho ba qositsweng, and ke tokelo ya motho a qositsweng e leng hore e a hlahella constitutioneng ya South Africa. Okay? That is correct?
Thank you. And according to the bail proceedings, what the accused said, not knowing the circumstances under which whatever was said to whoever, it's unknown, it's not before the court, it's a matter that has to be determined by the trial court.
And what's about it? Into a local atokopamili Mona Tamaisunya Hokopu happy. The total wheeling at the Guamotong at the Bakapasa Tebe Kapamoto, Amoteva, Kapasa Motebe, getting to tell you hore, Bulem Batona, but I'm Kela Katokil Kalania. That is correct?
Right. And I just want to find out from you, in a nutshell, you're saying the reasons why you opposing bail, you advance the following reasons. One, there's a high profile matter that was heard, that was even taken to the parliament. The community is saying the police are not doing their work, and the accused, 3 in this case, is scared for his life, especially from the co-accused, and the community is enraged, saying no bail. That's basically the reasons that you are advancing that the accused should not be admitted on bail.
Sheba Kennel, Mabaka hlaisitseng mo tabeng ya hore o hane o fana ka bail o ba kusuwa mona. La pele, we take case like case a high profile. E living ya nkelwa parlamenteng kwana. O bore hape le baka le leng ke taba ya hore batho ba setjhabeng ba bua ka moggo maponesa a sa etse mosebetsi ka teng. Le baka o hlaisitseng ke taba ya hore accused number 3 yane o itse ena o tshabela bophelo ba hae wa tshaba ene e kare batho ba neng a sebetsa le bona ba mo setse morao, and o bo bua le ka mokgo batho ba setjhaba ba kwatileng ka teng ba sa batleng hore ba qosuwa ba fuwe bail. Ke amang a mabaka wa hlahisitseng ao a etsang hore wena ebe ha ba tlo fana ka bail?
O jwale worship ke akaritse hore ha ba qosuwa ba ka lokollwa ka bail, ntho setjhaba se ka tloha sa nyatsa administration ya justice e lo re ba ka qetella ba nketse molao matsoho.
Yes, that included that if the accused persons could be released on bail, the community at large would frown upon the justice system and potentially end up taking law into their own hand.
The community at large, are you referring to Celtics? What are you referring to?
How about Basshaba, Ubuaka, Gabagaba, Basilti, Kapabuaka?
Including one of us.
I'm referring to the general community, including the Celtic fans.
What is the Celtics? What is the Celtics all about? What Celtics? Is it the burial society? Is it a what is it? What is the Celtics?
Celtic yo to buaka na ke enta. Elo re ke mokgatlo o patamba kapa Celtic ke eng mo gwa yona ante.
Celtic ke sehlopha sa balatedi bana ba latela soccer team ya Free State.
Celtic fans is a group of soccer fanatics who were supporting Bloemfontein Celtic Football Club.
Oh, so these are the fans that used to follow a football club. Is that team still there? Where is it playing? Do we know?
Well, kids supporters are Celtic in the club. Celtic club ayo, Celtic kapao tele.
You're not high school.
The club itself no longer exists.
All right. Okay, thank you very much, sir. Now, from what you say into the court, you're showing everything within your powers to say the accused should not, their version should not be believed. They are not honest with the court by giving us like ideas like accused 3. He has a car that's registered on his name. It's something that did not disclose to the court. There's an old house number that you're not so sure of that he also did not disclose to the court. That is, in a way, he's a dishonest person.
What I talk about ke hore ntho e leng hore ke le baka le tsang ho hane ha o le ha ho bua ka accused 3 ore ke motho se tshepahaleng ene bopaki ba hae ba o hlaisitse mona bo ska ba tshepuwa ba ska ba kgolwa le hore hona le address e nngwe eo a sa e hlaisang hore ntse le address ya hae ene le hore le koloi le yona e teng kae sa register wa mo mabitsong a hae ke one mabaka a o buang ka ona
ke mabaka ene e ke buang ka ona o se le ana ne ke bua ka setšhaba ka kakaretso le the interest of justice.
Well, those were some reasons that I was advancing as to my opposal, and those reasons did not end there. I also included the concern about the Celtic fans as to what their attitude is.
All right. Now let's hasten and move over to this issue of the way in which accused 3 was arrested. According to you, you say accused 3 called a police officer. He wanted a police officer that he could trust.
are kam kho accused number 3 a tshwereng ka teng wena o itse ho ya ka wena accused number 3 o founetse leponisa leponiseng le a batla ho kopana le leponisa la ka le tshepang. That's correct.
And he called, according to you, this police officer. What was this police officer's role in this case that accused 3 is involved?
Bona o founetse leponisa leo a go re bolelle karolo e bapetsweng kapa e bapalwang ke leponisa lena ke senior shebaneng le ke
part wa investigate team ya investigation.
That police official is a member of the investigating team.
Is it a white person? Is it Indian? Is it a black person?
Relevancy for that?
India.
No, Your Worship, I'm just trying to figure out the rationale behind the call and the conversation that they had. Certainly there should have been a conversation between the accused and the particular police officer who was there, and I don't see any prejudice by trying to figure out who is the race of this particular police officer. I see absolutely no prejudice in that.
Okay.
Thank you.
I understand though.
Is it a black person? Is it white? Is it Indian?
The police official was a black person.
All right. Now, you know what I found so difficult to understand in this whole matter is, if you would just apply your mind to this whole process, where would accused 3 get the numbers of this particular police officer that he called?
I want to say how I share by the way, and I can poke a shaban cutting. I choose 3 when I got from a guide in the Moza, the police alone, and Layla and the phone. I have no idea.
Yeah. Is it the reason why you don't know? It's because things did not happen in that way. I put it to you, they never happened in that way.
The way it's one Yoshi, the statement is a police, Zinelisiz, Usinotiguan, Mukusuaki and Amuletikiti.
But that is just as far as I know. Even the statement that the police officer made is written the same way as I'm testifying right now.
You feel agreed that it's human to err, right?
But you may cause the Malamuhatisi, Hargaiga suit, Kappa, Homotu, Fela, or Gaigai, I suppose. But I do not understand.
When my learned colleague asked you certain questions, you admitted to have made a mistake somewhere, and I'm saying it's human to err. It's every person can make a mistake.
It's more than now, not it puts out visiting zone. Where now, what you are more in the person. Jolly can take what you sign for a Mutuyemo Lemo or the Eta depots. That is correct.
And you say he said to this police officer, he's scared for his life.
When I was obligated to the police or
against the colleagues that he's working with. The co-accused to clarify the position.
And has a rate like this 100. When I we say on the Atabella Bopilo Bahai, Obana Bakusua Mole, now Magana of the Akoti. That's correct.
And you know that the accused was arrested on the 13th of April 2023.
What's regarding 13th April 2023?
Yes. And since that day, he has been, in all appearances that he has been coming to court, he has been locked up in the same cell with the accused before this court, and we have never had any complaint emanating from that.
And I shall not work on Satilio and Alona, I sale, and the Anali, Bakusha Mole Bona, Lenin, I go Anza Shailand Hotel.
In fact,
Kamatazia Shailand Hotel, Kawana, Ibile, Kaikai, Natsama, Aqualra, Lebo, never Kusha Mole, when I house so Kahuba, it's one and Leo,
in fact, he was arrested 2 days earlier, according to the charge sheet, the 11th of April.
Beg my pardon, Worship, thanks. On the 11th of April, 2023. Sorry about the date. He has been locked up here at the cells, holding cells, with the co-accused, appearing with him in this court, and we have never had any complaint whatsoever emanating from any of them.
And Hanzo had to have called to move. And hope and Libona more Jalo, also would go on a company, fake up by fake, a child, let's say, Kawakala, remember more sparking silly.
I get it.
Well, I do not know.
Thank you. Kenna, the reason why I'm putting that question to you is because there is no such a thing of fear of co-accused persons. And I think you'd agree with me that it's not like I deduce from your evidence that it's not like he's scared or fearing for the people that he doesn't even know to be, whether they are accused persons, whether they'll be arrested at any stage or not. I mean, I'm talking about people who are actually working at the institution.
Accused number 3 owner or Savanale, the co-accused it's a high. And happy how on a little back allowed us having to think about thing. Like Osibita Lena, Kapa, Kimutato, Swarang, Limutila, Atwang, Kufolia, and Atwang. Hazi, the Lokibo Mambao, so how long Bagaliga and Sangabe, our Pilobai, Hashanelua to Sabatini.
Yoshi Mukusua Giena Anabulela or Watsava for Bopilo Bahai. Jolaga Sigitaki City Lord Lina Analoids pointing out to group 4 Unai Patile Sefahio at Savare Habateva more.
Worship, like I have said, the accused person was the one who reported that he was fearing for his life. And even during the time he went to do the pointing out at the group 4 prison, he was covering his face, claiming that he didn't want his co-accused to identify him.
The accused during the trial, because we don't even know the circumstances under what you say was said, if it has ever been said, but then he will deny at the trial that he ever said something like that. He will tell the court exactly what happened, that in actual fact what happened is that he was home on that particular day, called by a police officer, and they told him that he must come to Mimosa Mall, and that's where he went and he was arrested.
Onale hae abafumana call ho tswa leponeseng le mo jwetsa hore le batla ho kopana le yena Mimosa Mall.
Worship Kwamagata ha Mkusiwa are yena o bitseditswe mo Samoa le bonesa lena le sebetsi mo Samoa ke dumela a ka ba bitseditse police station.
It's surprising when the accused person claims that this police officer called him to Mimosa Mall when the police officer is not employed at the Mimosa Mall. The police officer would have instead called him to the police station.
No, but Kenan, no one has ever said that the police is employed at Mimosa Mall unless you want to tell us something that we're not aware of. No one has ever said that.
That is his response to the issue that the police are the ones who called him, invite him to Mimosa Mall. And his response is precisely that. No, the police officer is not employed at Mimosa Mall. He would have called him at the most at the police station. Now he's being taken up in terms of no one said so. That is his response to the question. And there's nothing wrong with that.
Your Worship, no one has ever said that there's something wrong in that, with due respect. And we don't know what was in this police officer's mind at that particular time. But then, what I've got a problem with is the narration that says that he's employed at the mall. No one, I mean, it's given. No one's employed at the mall. No police officer is employed by the mall.
Yes, Mr. Makamedi.
Thank you, Ocean.
You may proceed then.
Thank you. Yes, you see, even the time he was called to the mall, he was not even arrested at the time.
While Kalena Boyo are appealing Molong Mo, Onaspe Afharwa Kanabuyi.
And you further said in your evidence that it will take you a month to 2 to have these investigations in this matter finalized.
And a Pakiba is a tongue of Pedi, who is a Pedin Pedi, or the Kukuza case in a different. That's correct.
You say more people are still to be arrested.
Or Unzula to Baba and Happy Bansim Batwa case in me. That is correct.
And you know that you cannot use or you cannot arrest a person as an anticipatory to a form of punishment. Okay? You cannot just ask the people to be locked up with a punishment in mind. That's not the purpose of bail application.
And what's about us? I said, Tawarabatuara Hore, if they say ele have a panishu. Evident to you, as a space, Kopea bail.
Mr. Magami, do you intended to say arrest?
Your Worship, the purpose of bail application, that's what I'm saying. You can't keep the people in custody for purposes or to continue with your investigation with the purpose of anticipating a form of punishment. That's basically my question.
Okay, what's okay? Ogasi, be able to clamo. Elore, wena, osonali tebello, ya ore batu bao, batu panishu bao. Hasis pio sa kubo ya be ilise. Ogasi be able to fail, onali tebello ya ore tletelo batu batu panishu. That is correct.
And you know for a fact that a person that has been arrested, the person remains innocent up until proven otherwise by a competent court.
And whatever remoto atwering, unkua asina molado, kufihlela, le hota la dinyewe, le hore nale bipihlelo nale bitsana pebo, ebalona. That is correct.
Thank you. And you said in your evidence in chief that accused 3 is dismissed. Edwin.
And we say accused number 3, that is so.
Do you perhaps know when was the disciplinary hearing?
You know, it's like
accused 3.
Disciplinary hearing, yeah, accused 3. In a journey.
Hakina diditi Satimayoshi.
I do not have the dates of the disciplinary hearing.
And you know that the accused is not employed by G4S, it's not even employed by the DCS.
Yeah, what's about it has accessibility G4S, happy accessibility DCS. That's correct.
If you contacted Integritan Security to find out his position.
When I will our phone Batuba, go up contact Batuba Integritan Security. About in a position high in Mere. Yes, I did.
But let me correct you here, Captain Kenna. The accused is not dismissed that well. On the day of his arrest, the 11th of April 2023, he was actually off.
Accused number 3 halele kwa msebetsi. God 11th April 2023 muntu eno onale off.
Na sekisifumani worship oto ulelekwe.
But what I obtained from my investigation was that he was dismissed.
Yeah, you see, this is quite disturbing in the sense that a person is off on the 11th, and then he then gets a call, he approaches the police, he gets arrested, and all of a sudden there was a disciplinary hearing and this person is dismissed in his absence.
I want to hear this step. Yeah, that's fair. About the Mutukiana or for Ufumana Koloma policing, Yena Oya, the police and the phone thing. Personally disciplinary hearing kabakalaure yena aikiste mo anafoni to tengi le ponisa ebe hosothwe wale lokuwa msebenzi
Na sekisitsiba worship gore ke hwetsitswe ke bona bare ulelekile mosebetsi.
But what I know is that I was informed by them that he was laid off from his work.
Yeah, but the person might have given you wrong information because according to him he's still employed there.
Muto no bua le nna kana ba o file information e wrong. Hobane o ya ka yena o ntsa sebetsa ntsa sebetsa mo ntsa sebeletsa integrity ni everything.
Bona bare ba molelekile worship.
But his employers say they have dismissed him.
Right, let's proceed. And when my learned colleague asked you about the blankets, you said there are blankets in prison. Do you even know where this accused it's locked up?
Sheba muchismona na about ana botsa hona dikodi teng mo ka dikodi le kane wala o itse no dikodi teng mo motho a kwaletseng teng wa tswa motho o kwaletswe ka
Ho jwalo yoshi.
Yes, I know.
But have you been there to see the people locked in there as to whether they have sufficient number of blankets? Or do you even know how many blankets is he using at his own house to sleep at night during winter?
Iwe kile wa yona mo walo sheba batho ba kwaletsweng ka mo hore na bana dikobo tse anetseng and le hore na di uka dikobo tse kapa wa tseba hore na yena o sebetsa dikobo tse kae ha.
Yeah, but as for other people, would it be necessary for him to go and check how many blankets are they sleeping with? Can you just limit to your question to accused number 3?
It's fine, Your Worship, but I do not see any wrong in the type of question that I've asked.
Yeah, but
in the sense that, if the court can just allow me to explain.
Yes.
In the sense that this is a bail application. Hearsay is admissible in bail application, and we have been hearing that even the members of the community are saying it's on behalf of other people. That has been allowed throughout.
I don't have a problem with that, but to generalize to say other people, You must limit your question to accused number 3.
Thank you, Your Worship. Thank you, Your Worship.
Thank you.
Have you been to the prison to see how many blankets were or are available for accused 3 in the place where he's locked up?
Ukila wa tronko moe. Olo sheba rona dikobo ofue kapa allocated dikobo tse kae hore re bala ka tsona mo a kwalletsweng teng.
Ha ke so Your Worship.
I've never been there.
So his version would stand to say that he's given less number of blankets and as a result he's getting cold.
Jole ntwa buang e tlo stand up. It tlo ema mona lekgotleng la hore ntho ya hore yena dikobo tsa difuang kwana kwa kwalletsweng teng ke go tse mmalwa tse nyane and wa hatsela ha di mo ane.
Ke dumela Your Worship hore ha hatsela a ka kopa fuwa dikobo tse ke dumela le tronk e kebe ya hana ho mo fa dikobo jolo ka hanentse a kopile le nako yane ha le otindale hore o kopa hore a iswe Sosolbeke prison.
But I believe that if he was getting cold in any way, he could always go to the prison officers and tell them to give him more blankets. And I don't think any officer would refuse to give him more blankets.
Yeah.
And he even made a request when he was locked up in ordinance arrest that he should be taken to a different prison. And that was hidden.
Unfortunately, sir, that's not the position. He was never given extra blankets, and as a result, he contracted flu. And when he went to the health facility in there, all that they could dispense was a Panado.
Seba tshweo e buang ha e ka mkho wena be bolelang ka teng o hanetswe ena ka dikobo tseo ka mkho wena o buang hore ka se hane a se ka mkho e etsetseng ka teng ibile ka baka la o ile a ba a tshwaetswa ke flu mo ya ba ha a ya ko facility tsa health tsa mo prison mo ke a fuwa Panado fela
Ho thata ron ka tshwaela.
Well, it's difficult for me to give a comment on that.
Thank you. So the accused doesn't have a passport, right?
Hana passport to accused, okay? Correct?
And there is no ties of him out of the Republic of South Africa that are known to you.
And I wanna makama ahai kantle ho Republic e wena o watseba.
Che hai ha ke tsebe.
Yes.
And on those basis, you cannot say that he's a flight risk. He's unlikely to stand his trial if released on bail.
Ene ho ya ka ntshwana e re bua. Ha ona ka mkho wena o ka mo beang le fapeng la batho ba ene hore ba ka baleya nyewe ya bona ile hore ke motho a ka skitlang a tla case nya a re eme.
A ke tsebe.
Well, I don't know.
Right, and yes, we admit that the accused are facing serious charges, right?
We ametse tabare ba kusua ba tobane le diposo tse ding tse mpe ka ho fetisisa, okay? Correct.
But that's not the only determining factor to determine whether they are eligible for bail or not.
Empa ntho a sona fela e nkelwang hloohong ha o tlo nkuwa tshwaetso hore na batho ba e fumana bail kapa ba e fumana.
Ha ke tsebe Worship.
I do not know.
On the issue of the community saying no to bail, I want to say to you, the accused, this incident took place more than a year ago, right?
Motaba ya hore batho ba re batho ba ska fumana bail ke batla hore wena ketsalo ena e etsahetse nakong e fetang selemo e fetileng. Okay? Correct?
And the accused was a member or part of the very same community that you're referring to, and he is rooted in Bloemfontein, which is something that is not disputed. He stays in Bloemfontein in a particular house. You mentioned the address that you confirmed.
And the accused in a community in a Ubankayo. And Kimoto Elo Hore Otepami Mona community, United Bloemfontein, Eunzum Wakayo Una lento moa dilante ona mona Bloemfontein.
Kana go tse setšhaba ne sa tsebe hore mokosi wa o entse.
At that time, the community had no idea what the accused person had done.
But are you saying that the very same community that you're referring to, I didn't know that there was an escape at G4S, wherein an inmate was aided by people working in there?
What I'm telling you, setšhaba se ne sa tsebe hore ho bile le escape ko G4S mo le hore motshwaruwa o thusitswe ke batho ba sebetsang mo.
Sena ke dumela ha ke sa fotse yoshi se hlahelletse ka bo matchi e ba public domain ya hore ho etsaetse eng ka hara G4S.
If I'm not mistaken, it all surfaced around March, and it came to the public attention what actually happened at the facility.
The question is, are you saying the community was not aware that a person has been aided to escape prison over a period of 12 months?
Potso ke hore na ore batho ba setšhaba ba ne ba sa tsebe na hore ho na le motshwaruwa a thobileng tjhankaneng a thuswa ke batho ba sebetsang mo selemong kaofela dikgweding tse 12 kaofela.
Jwalo ka se ke tsholo hore ke dumela bongata itse ba itse ka March ha ne ho postwa photo ya Thabo Bester hore ke yena ba mmone a le ulwe kana go tseno setšhaba ne le silile fifi ba sa tsebe hantle ho etsana.
Just as I've said, it only surfaced in March, and it became in the community's attention only in March that there was such a thing that had happened there. When Thabo Bester was posted in social media, claimed that he had escaped from the prison.
Kenneth, I put it to you that this matter was known by the community that you're actually referring to, that this is what has taken place in March, is it March? In May last year. Already, it was known.
Can I tell you it's a bahala hore into it's in May last year.
The accused at that time was rooted in Bloemfontein, and nothing has ever happened to him. And I put it to you that should this court exercise its judicial discretion to grant the accused bail, nothing will happen to him.
And kana go go fela. Accused 3, I said na tsa ituletse a le mona Bloemfontein ele hore na le we tula Bloemfontein ho sna letho le etsalang ho ye. And ntwe ke batla mo jwetsa na ke hore le khotla lena ha le ka etsa kitso ya yona ya se molao ya la lokolla accused. I want to say
yeah, that was a long question. Let us break it. The attorney says the community knew long time ago from May 2022 about what happened. What is your response?
Well, o tse potso ene le telele re robe dikoto ya pele ke hore Mweli ore ka May 2022 community in eNCA ba country ore ngwe
Chair, how usual worship.
That is not so.
Then accused number 3 rooted out in the same community of Bloemfontein, and nothing happened since then about him.
Jale ho ba le karolo e nngwe ya potso e reng ha esale a le ka May 2023 ntwe e etsahetse a tsa le community yona yena a tlameleng a lokollelwe ho yona ha ona letho le etsahetseng ho yena.
Ke dumela worship hore ha jwalo ka se ke tjho setjhaba se ne se sa tsebe ka hore ba o entseng party ya e bapetseng hodima escape ba ntwene ene tsebala worship kana go tseba ho no tsejwa fela ho Thabo Bestere o committee suicide ka hara president for
Worship, I believe that the community at that time had no idea what role accused number 3 might have played in the whole situation. And what I know about what the community knew then was that Thabo Bester had committed suicide inside the prison facility.
And should court grant accused number 3 bail, nothing will happen to him, as nothing happened to him before.
Engwe karolo ene le yona e hore le ha le khotla le ka mo fa bail ha ona letho le tlo etsahalang ho yena hobane ho nontse ho sena letho le etsaetseng le pele a tlo tshwa.
Ki dumela worship hore ha ntho o tla le setjhaba se ka motswela matla ho ya ka ketsahalo le hona jwa le lore ntho etse case ena e tsebala jwang go go etsaetse le yena moqosuwa sa se kopileng hore are ki tshabela bophelo ba ka hobane ena o fane ka tshedimosetso ho tloa party ya e bapetseng le bomang ho fihlella le ka hore ditopo di kene jwang le teng ke ntho ya hlalositseng admission statement ya hae.
Thank you, Master Makamedi.
Your worship, I think if the accused person can be released on bail, the community is definitely going to be after him, and the accused person has told us what he knows about what happened, and even he, according to his request, he has said that he is fearing for his life, and he told us about the information. He told the police officer about the information that he played, and he even told every person into detail. He told the details about what each and every person played and how the corpse even landed at the prison facility.
As I said earlier on, you don't know the circumstances under which that was done, and that is a matter for a trial court.
Jalo ka ditse ke buile ha re tseba bona motho ha beneng o di buile ditho tse ona di bua ka tlasa mabaka a feng, and ntho eo ke ntho e le hore to sekasekiwa ke lekgotla tshekelo lekgotla le sekang case ka bona. Well, that's so.
Thank you. Would you agree with me that because there's never been any disciplinary hearing against the accused, is not aware of who could be the witnesses in this case?
O dumelana le nna ha ke re ka ba kana ha o so ka ho ba le disciplinary hearing khatlana le yena ha ka se khone o tseba ile ke bo mang ba go batho ba ditipaki.
Or let me put my question in this way. Because there's been no hearing, the people that would have testified in that hearing are unknown to the accused, the accused three.
Ha re be ka mkhotsi ena ka ba ka la hore ha ka ha ba le hearing kgatlhanong le ene le batho ba neng ba ka batla hearing ya hae ha tse ke bo mang tsatsing
ha ke tsebe ka hore na ho sena hearing.
Well, I do not know whether there was a hearing or not.
There was none. I'm telling you, there was none.
Ka o jwetsa ho no sena hearing kgatlhanong le motho ha o soka wa le hearing kgatlhanong le ene.
Right? You know, in bail applications, the court can attach conditions on the bail, and if the accused, for whatever reason, fails to comply with the conditions attached, then the person can be rearrested.
Wa tseba masehemo di tabeng tsa bo dikopo tsa bail le khotla le kana la fana ka di bail tse no hore motho a tsuleng ka bail ha sa ikamahanye le tsona dipeelo tseo a ka tshwarwa hape a kgutlisetswe ka hare.
Ma bakeng sena na for accused ne ke kopa lekgotla hore le ske la mo fa bail jwalo ka section.
But in this instance, I would plead with the court not to grant the accused person bail.
No,
as I've already said before.
Yeah, no, I hear what you're saying. I hear your request to the court, which the court will deal with it at a later stage. But what I want to figure out from you is that you do know that bail can be, conditions can be attached to the bail.
Yeah, can you control when I open the hotel? Ntse ba tla go botsa na ke taba hore na wa tseba hore hona le dipelo tse ka beuwang le bail ha motho a lokolotso botse ha o lokolla o etse tshina ha o le kantle ka mo.
Ke a tseba yoshi.
Yes, I know.
Thank you. And the other thing that I wanted to ask you is, you know that a picket outside this court does not influence the court's decision when coming to bail application. The court has to exercise its discretion. It's not an issue on its own.
What's my le picket e tsalang ka ntle go meao ena ya lekgotla ha ina tshusumetso e feng kapa e feng qetong e tlang buang ke lekgotla ntse le lekgotla ntse le tlamehile lona le tlonka diqeto tsa lona ho latela ka mogodi ditaba di hlahiletseng ho lona ka teng.
Ho jwalo yoshi.
That's correct.
You should just approach.
Yes.
Thank you, Worship. Just last aspect that I didn't take up with you. It's the address that you mentioned in your examination in chief, that you said is appearing on the accused e-notice documents. For his old battered car, if I may put it in that way. Remember?
So I want to say about Kayona in hore ile mabapile address ono bua Kayona mo eno hore ile hlaela mo information ya Tuesday ene ke ditse le kekolo ya ya gale le sentse sa tlele sebetsa sa o pola lo bule ka ona ka mo ona le address engwe ka teng.
Ha ke sa fosi worship ki ile ka re ki bank statement ya ha.
If I am not mistaken, I said that it was the address that appeared from his bank, from his Capitec bank statement.
Oh, okay. And you say the address is 15750 Joseph Letzualo Street, Bloemfontein.
15750. Yeah, we say address okay 15750 go Joseph Letzualo. Onamana Bloemfontein. That's correct.
And yes, indeed, you said it's the bank account, correct. If you conducted investigations to check who stays at that address, or is it an address that can be found or not found?
What's the Kuputo mo? Or an address a man, Kapaki address a Fana of Manea, Kapaki address is a Fanu of Manea. I did not conduct any investigations pertaining to that address.
Okay. So you won't dispute if I say the address belongs to the father of the accused?
So Anna Goblela or Ki address a young tate, Omukusua, or Cascono Hananale. I do not know.
Thank you, Chief. That's my cross-examination on this witness. Thanks.
Thank you very much. Mr. Kwenane.
Please, the court, Your Worship. Another colleague has just indicated, brought it to my attention that it is 3:30, but I'm ready to proceed if the court is so inclined that I should proceed.
Yeah, I would not prefer to deal with the cross-examination on the witness on a piecemeal. We should rather roll the matter over if it's possible.
I'm in the hands of the court, Your Worship.
Yes, I think this is an appropriate time for this matter to be adjourned.
Is the court thinking of tomorrow?
No, I said it may be rolled over. I'm not necessarily saying tomorrow. It depends on the availability of all the legal representative and the public prosecutor.
Unfortunately, I'm not available tomorrow and on Thursday. I'm chairing interviews, which unfortunately cannot be postponed as candidates already have been invited and are on their way. I'm unfortunately not available. I'm, however, available on Friday.
Mr. Mururi, is your schedule?
Your Worship, I'll fall in line with Friday. So God, please.
Mr. Makamedi.
Your Worship, it's very unfortunate that I'm not available on Friday. I'm also not available even tomorrow. I also have interviews to conduct tomorrow. So it's just unfortunate. The only time that I can be avail myself is on a Thursday, but
okay. Mr. Kwenane?
I don't know. I'll try to be in line with whatever is proposed pertaining to the dates. The sooner the better.
Thank you. Mr. Keripota?
Worship, the first available date I will avail myself, Your Worship.
Okay.
I was thinking of Friday, but unfortunately my colleague is not available.
Yes, we can check next week. It is clear that it's not practically possible for this week.
Monday, Your Worship?
22nd?
I was proposing Monday and Tuesday, but it appears Mr. Morori is not available on both days.
Your Worship, let me just confirm that indeed I'm not available on Monday and Tuesday. Perhaps, Your Worship, if I may be, yes, if perhaps we could take a short adjournment. I believe these great legal minds will come to a date, Your Worship.
I hope you are not insinuating that this one is a very little man.
That is a fountain of wisdom, Your Worship. I would never insinuate that.
Thank you.
As the court please.
All right. Court adjourns.
All right.
/113/2023, Sinohe Ishmael Maswara and the others. Bishop, thank you for the indulgence, and we managed to come to a sort of a compromise. It would appear that Friday, the 19th of May 2023 is suitable to all of us. Mr. Magamedi maybe will address the court in terms of what the situation with him is, as a please.
Mr. Magamedi.
Thank you, Your Worship. I indicated to the court that I'm not available on Friday, but seeing that we done, I'm skeptical to say that, but seeing that we're done with the cross-examination, I'll ask my learned colleague, Cecil van Wyk, to stay in for me, and the matter can then proceed. If there's any other thing that may crop up that would need my attention, he'll give me a call and we'll see how do we proceed with that. Thank you.
In order, Mr. van Wyk, can you confirm this?
Your Worship, I confirm. As it pleases.
Thank you. Mr. Kwenane?
The date that has been proposed is suitable for us, Your Worship, and we would be ready to proceed. As it pleases the court, Your Worship.
As it pleases the court, Your Worship, I confirm the date and I confirm we will be ready to proceed.
Thank you. You may rise up then.
May I also humbly request all court officials that perhaps we try our best to start at 9 on Friday. I don't know. I know the court has other matters already planned, but we can make some arrangements. If we can start at 9 on Friday, as a president.
Okay, Susan. On Friday we will be starting at 9 o'clock. You will be ready. Thank you. Right. Case is remanded until the 19th day of May 2023. Same court number 20A. For further evidence on bail application. The accused will remain in custody until then. Thank you.
As the court pleases, Your Worship.
Oh, hey, Colonel Flyman, I always forget to turn my head to you. You are also warned for 8:30 and to remain in attendance until you are duly excused by the court. Failure to adhere to this order, warrant of arrest will be issued. Thank you.
And he will execute it himself. Joseph, we may now, I suppose there are no other matters.
Yes.
We can then adjourn for the day. Thank you.
Court adjourns.